It will be. The senators had converged this morning to look at some of the preliminary charges that have been leveled against the governor. They have taken an in-camera session and they'll be back at exactly a few minutes to, of course, 10 a.m. And once they do come back, we'll be taking you there live once more. But before I deliberate even further, I'm being informed that the Chief Justice Martha Koome is currently presiding over the swearing-in of Mr. Abdullahi Kassim as a member of the National Heroes Council and also state appointees to the National Police Service Commission. There you have it. She's still speaking. The Chief Justice, let's listen in.
To collaborate with you and offer coordination to build a criminal justice system that inspires public confidence and safeguards the rights and safety of all Kenyans. And to our National Heroes Council, you also hold a unique and noble mandate to identify, honor, and preserve the legacy of those who have made outstanding contributions to our country. This responsibility is not just about celebrating past heroism, it is about nurturing national pride, preserving collective memory, and inspiring our future generations. Therefore, Mr. Kassim, in your new role, you join a team entrusted with identifying and supporting our national heroes and heroines and advising on their recognition as well as their welfare. As the Council undertakes this huge task of honoring our national heroes, I encourage you to celebrate individuals while they are still with us, recognizing their contributions during their lifetime, thereby affirming our national gratitude and strengthens our culture of patriotism. You will be charged with the responsibility also of preserving the legacy through monuments, archives, and educational programs, which will ensure that future generations will appreciate the sacrifices and values that shaped our nation. Equally important is the recognition of everyday Kenyans whose extraordinary acts of uplifting our communities is not recognized. But we need to celebrate these unsung heroes who promote a culture of service and compassion and who inspire others to follow their example. My final reflection to you, Honorable Commissioners and member of the Heroes Council, is to remind you, which I always do to all the people who take this oath of office, that the oath you have taken is solemn and sacred commitment to uphold the law, to serve diligently, and to act always in the public interests. These responsibilities you carry are immense. I therefore encourage you to discharge your duties with dignity, with courage, humility, and excellence as you serve Kenyans. I wish each one of you every success in your new roles and assure you of the judiciary's unwavering commitment to work with you in the service of our nation. Thank you, and may God bless you as you serve the Republic of Kenya. May He guide you every day and shine His light upon you. Thank you very much.
Well, that was the Chief Justice Martha Koome, of course, presiding over the swearing-in of Mr. Abdullahi Kassim as a member of the National Heroes Council and also state appointees to the National Police Service Commission. Our very own Andan Ibrahim is following on that particular story, also keeping an eye at Britam Towers, where the National Cohesion and Integration Commission will be currently speaking on the current state of peace and cohesion in the country following the Saba Saba protest that was witnessed across the country yesterday. As and when we get that particular link, we'll be going there live. resolved. But our keen focus today is on the Senate following the impeachment of Isiolo Governor, that is Abdi Guyo, where 16 out of the 18 MCAs in Isiolo County Assembly voted to the impeachment of Isiolo Governor. Now, you do know that the MCAs had leveled up various charges against the current governor of Isiolo, who was a Nairobi ward representative earlier on. And of course, he went to Isiolo County and became taking over from Kuti and becoming the governor of Isiolo County. Now, you do know that there are various charges they have leveled against him, and the senators will be considering those particular charges, including the irregular appointing of 36 advisors as well as 31 chief officers, awarding flawed contracts and stalling projects in the devolved unit. Now, you do know there are scenarios that are likely to play out on the floor of the Senate, where all 67 senators will be partaking in the hearing. But when it comes to voting, only the elected senators, who are 47 of them, will be taking it to the poll. And once they do that, they will render their verdict. 24 out of the 47 MCAs are required to save him or impeach the governor. And of course, joining the long list of former Nairobi governor, that is Mike Mbuvi Sonko, former Kiambu governor, that is Ferdinand Waititu, among other devolved heads who were impeached, and others who were impeached by the county assembly, saved by the Senate, others were saved by the courts. We are waiting to see how that will pan out. Joining us is none other than Sami Meli, political analyst, to talk about what are the outcomes or likely scenarios we're likely to see on the floor of the Senate as and when they resume. As I told you, I'll be coming back at exactly 10:40, 10:50 there about to continue with their hearing. Meli, good morning.
Good morning, Hashim.
How are you?
I'm very well, thank you.
It's another day, another governor on the chopping block. We witnessed what happened to Kawira Mwangaza, who faced numerous impeachment from the Meru County Assembly. Now we do have Isiolo governor, that is Abdi Guyo. Maybe give us your opening remarks towards the impeachment of this governor.
The impeachment of the governor of Isiolo is actually one of the things that the new constitution has given us. It is the county assembly, ensuring that there are checks and balances, ensuring also that our resources that have been devolved are properly used and properly utilized, and the people responsible are accountable. And therefore, he joins the longer list of governors who have been impeached. And I hope the justice will be served in the Senate. Remember, there are quite a number of charges against him. And remember, irregular appropriation of especially the contracts that most of our leaders end up meddling and interfering with the procurement, and at the end of the day, the contractors are left unable to even execute their mandate. And sometimes even the contractors who are not qualified end up getting a contract, and they don't fully implement what was agreed upon. And it calls us as a nation to look at the moral fabric in this, all this. You remember some governors have also employed their relatives into the chief executive positions. They are allocating the contracts to friends, dishing out like it's Christmas gifts. And at the end of the day, you find that the genuine contractors don't get it. The genuine civil servants or people who are qualified to do the job don't get to do the right job. Because of these skewed ways of doing things. I hope the Senate will, I know it will hold a public plenary where we will see and follow through the discussions, the impeachment motion. I hope also the governor has prepared himself with these lawyers to counter the charges. And remember, for every governor who has been impeached before, if they don't appeal, or if they appeal and lose their appeal at the end of the day, they cannot vie for any other elective position, and neither can they be appointed to serve in any public office. And that calls unto all of us as Kenyans that we should check our moral fabric. We should check on the executive, especially the national executive, I mean the national government, the executive arm of government. We should also check on the executive arm of government and the county governments to make sure that the resources we have allocated. It's painful to have your salary deducted as pay as you earn, to pay taxes, and then they are misused and they are dished out like Christmas gifts. You have seen the young Kenyans complaining, even the employed Kenyans complaining about the deductions being done. If the deductions are done and a prudent use of resources is done, and we can see good way of spending these resources, then we will have very little to complain about. But if there are, you see somebody who joined the county executive committee just the other day and now is driving a very heavy Prado, actually with a convoy, you wonder how much are we paying this person? Sometimes you see the salary is 200,000, but how do you end up getting 12 million worth of fuel guzzlers, machines, and they end up living even lavish lifestyles.
Okay.
Yeah.
And Meli, what we're talking about, you see, since the advent of devolution, since 2013, we have seen at least 10 impeachments, over 10 impeachments of governors across the country. You do know even the first governor, that was Granton Samboja, but he survived when he went to the Senate. Until the latest one, we have the Isiolo governor, Abdi Guyo. What does it say about devolution? Where are we and where are we headed as a country?
Devolution, if we look at it, is devolved corruption. In some counties, you find one county is proceeding so well, others are lagging behind in development, in the use of resources. And then when we look at the impeachments, the about 10, as you have said, it's not actually cast on stone that Abdi Guyo will go home automatically. The Senate will consider the evidence presented before it, the pleadings before it, and then, you know, is a judicial, it's like a judicial arm of the legislative legislature. And therefore, what the Senate will pass can only be overturned at a higher court when it is appealed. And I know most of the senators are sober, and they will look at what has been presented before them. Yes. I hope there will be no brown checks doing the rounds in the toilets. But the Senate has of late seemed to be a very independent-minded institution, and we expect that justice will be served. You see, justice delayed is justice denied. Let Abdi Guyo, Governor Abdi Guyo, clear his name, clear by explaining the expenditures, explaining their appointments. If they are really on merit, then he will escape the net. If he will not be able to defend himself well, he will unfortunately join the longer list of impeached governors.
And of course, let's give our viewers a little bit of context. Also here that we do have that particular story following the impeachment of Isiolo governor, that is Abdi Guyo. And of course, as I told you, we'll be heading to the Senate any moment from now at exactly 10:30 or 10:40 thereabout to continue with that particular hearing of the impeachment of Isiolo governor. Before we give you the outlook of how the session will continue for those particular 2 days, let's get to hear and recount that particular impeachment of Abdi Guyo as Isiolo governor. Of course, we'll be getting a hold of that particular story as well. The session will continue in the next few minutes or so. It will be, the Senate will be giving out an outlook between 10 to 11 when it comes to the mandate of the Senate and House Rules Procedures. After that, the County Assembly as well as the Senate, the Governor of Isiolo County, of course, through their legal counsel, will be giving their opening remarks. Let me just get a hold of the legal representation. It is already out, both for the County Assembly and the Governor. Now, let's start off with the County Assembly that submitted a list on the 4th of July, will be led by none other than the Dr. Ekuru Okot, an advocate. They also have brought forth Mwereru Boniface Moira, who is also an advocate. After that, the County Assembly has also brought forth Mwirigi Eric Murioki, an advocate, Jamal Abdikadir, Chalo Kennedy Maweu, Paul Wafula, an advocate, also Koskei Alvin Kemboi, an advocate, Diana Busire Nyaboke, an advocate, and then finally also Mugambi Kennedy Mutua and Hussein Kasim Roba. Those are among the legal representation that will be getting to the County Assembly. Also, the members of the County Assembly shall shall be called to as witnesses will be Honorable Abubakar Abdi Godana, MCA, Lematile David Lorat, Nicholas Ewaton, Peter Losuloyan, and MCA. Those are among the members of the County Assembly that have been fronted as a witness. Also, Anna Bakasim and Abdirahman Mohammed Ibrahim. You do know that the representation of the members of the County Assembly cannot supersede 3. Now, the members of the County Assembly will be represented on the floor of the House by Lemantile David as well as Peter Losu Layan. Also, quickly, let's take a look at some of the additional lists that the County Assembly also brought forth in terms of legal representation. Paul Nyamodi has been added, Alex Mbaya, Patrick Baraza, Brenda Mwangi. Those are among the legal representation that have been added to the long list of legalese that will be representing the County Assembly. On the side of the Governor, his lawyers will be Elisha Ogonya, an advocate of the High Court, Eric Theuri, Elias Mutuma, Tali Israel Tali, Marcelino Lesangor, Miriam Rebecca Abong, Ruth Kiunga, Nura Abdul Qadir Nura, and also legal assistants that will be aiding both sides. That is a total of 11 lawyers from each side, including the legal assistants. And the Governor will be calling upon the following as his witnesses. That is Salah Boru Guracha, Habiba Galgalo Jirma, Honorable Abdinur Dima Jilo, Honorable Diba Abdirashid Ali, Shaban Muzungu. Those will be the witnesses that the legal representation from the Governor will be calling upon. But as I told you earlier on, we do have that particular story on how did we get here on the impeachment of Isiolo Governor Abdi Guyo. Once we air that particular story, we'll come back with our conversation. Have a look.
Isiolo Governor Abdi Guyo will now face the Senate plenary in a high-stakes impeachment hearing after efforts to form a special committee to investigate allegations against him collapsed on the floor of the House.
Pursuant to Standing Order 48.3, received a message from the Speaker of the County Assembly of Isiolo regarding the passage by the County Assembly of a motion for removal from office by way of impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County, pursuant.
The Senate was forced to abandon the committee route after a motion by the Senate leader of the majority party, Aaron Cheriot, presented by Senate Whip Boni Halwale, failed. This is after the second Akilifi Senator Stuart Madzaya objected, prompting the Speaker to direct that the matter be handled by all senators.
Members, you are either choosing that we form a committee or we go to plenary. I want to appeal to you to weigh on this very important issue, because the country has a lot of confidence in us. They should see that we have given the Governor of Isiolo the best opportunity to be heard as this decision is made.
Mimi napinga hoja hii ya kwenda kwa njia ya kamati.
Point of order, Speaker.
Nataka kwa hiyo hoja hii mimi naipinga vikali sana na sikubaliani nayo.
Having been negatived, the route of special committee is abandoned, and that implies that the Senate will investigate the proposed removal from office by impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County, in plenary, pursuant to Section 33(3)(a) of the County Governments Act and Standing Order 81B(2). The Senate shall then investigate the matter in plenary on Tuesday, the 8th of July, and Wednesday, the 9th of July, 2025.
Kingi further directed that the clerk sends the invite for parties to appear by the 1st of July and file responses by the 4th of July. The clerk was also directed to circulate documents received and the plenary program to senators by 5 p.m. on the 7th day of July, ahead of the commencement of the investigations and the determination of the matter on the 8th and the 9th of July 2025. Governor Guyo was impeached by Isiolo County Assembly on the grounds of gross misconduct, abuse of office, and violation of the Constitution. The charges include the irregular appointment of 36 advisors and 31 chief officers, failure to renew contracts for key county officials, and alleged mismanagement of public resources, leading to stalled development projects.
Appointing chief officers under 2-year contracts, thereby creating a climate of fear and uncertainty contrary to Articles 73(1)(b) of the Constitution, and failing to renew the contracts of County Executive Committee members, significantly affecting the continuity of service delivery in the county. And 4, appointing 2 deputy county secretaries to positions that are neither recognized in law nor provided for in the county staff establishment.
The Senate proceedings come amid legal uncertainty after the High Court nullified the impeachment vote, citing contempt of an earlier order barring the process.
Well, if you're just joining us, that is our keen focus, the impeachment of Isiolo Governor Abdi Guyo. That was a precursor, a report done by our very own, that is Gladys Mungai, on how we got to a plenary session as opposed to an 11-member committee that was, of course, rejected by Stewart's Mazayo. Now, all the 67 senators will partake in the hearings, but the people who will crucially vote on this particular matter will be 47 senators, out of which at least 24, which compose the majority, will have the final say on either to save or, of course, uphold the impeachment of the members of the County Assembly of Isiolo County in terms of impeaching the governor. Also, the members of the Senate will be considering some of the allegations that have been leveled against the governor and listening to both sides. If you're just joining us, legal representation from both the County Assembly and the governor's side have been brought forth before the Senate. And a moment from now, we'll be crossing over there live and we'll hear from both legal point of views from both the governor and the County Assembly. Also still with us here is Sami Meli, a political analyst. Meli, what are the likely outcomes we're likely to see in the next 2 days, given that this exercise will conclude tomorrow?
Now, we are likely to see the governor defending himself with a spirited effort. Remember, 16 out of 18 MCAs voted to impeach the governor. And therefore, this tells us that the hearing at the plenary will give a governor more space to defend himself, and therefore will also get an input of more senators into this. Remember, if they were gone to a committee, then there would be few senators listening to the case. But now we have the whole House listening, and therefore whatever they will come up with, it will be a representation of the overwhelming majority. Whether they will be split in the middle, I don't know what will happen, but it tells us that these members of the County Assembly have had enough reason as to why they should impeach the governor. They are not madmen and women down there in Isiolo. They are very decent people. They have exercised their constitutional responsibility. They are representing the people of Isiolo. Remember, each member of the County Assembly represents a ward. And in this ward, there are people. And therefore, in this country, are governed by a representative democracy. And therefore, when we are working with a representative democracy, it is assumed that a member of County Assembly has voted on behalf of the entire ward. And therefore, the senators also will make a decision. And when we have a whole plenary, it means the whole nation of Kenya is represented on the floor. And we will hear the charges. Remember, he had a court order stopping his impeachment at the County Assembly, but the County Assembly ignored it. Now, the Senate will help us also interpret whether proceedings at the County Assembly can be halted by a court order. Remember, we had the same happening when Governor Wambora was being impeached.
Yes.
We remember the same in Kericho, governor's impeachment. And therefore, when these things happen, it tests our constitution. And remember, what will happen will build on what the future impeachments that will come. It is in the process of strengthening our constitution. It is in the process of strengthening our democracy and also transparency. And it also helps us deter other county governors who might have the same behavior. It also a wake-up call to other MCAs elsewhere. Perhaps if the governor is going towards the same road this other governor has gone, then they have a chance to impeach the governor. And remember, sometimes impeachment, people think it is because of hate. Sometimes even, remember, impeachment is correction. If the Senate will stay the impeachment, that means the governor will know that I was wrong in whatever I did, and perhaps he will get time now in his free life to look into his life. If he realizes that actually he wins at the Senate and the impeachment is dismissed, perhaps now he will go back to the county knowing that there are people watching. There are people who want me to be accountable. And therefore, if there will be any loopholes, he will be able to seal them.
And you're saying it will be an improvement for governors. Impeachment is not an indictment. But is it not a bad indictment, Meli? We're talking about once you're impeached, you can never hold any other public office.
Yeah, because it's the same thing. We have criminals. You see, once you are impeached, it's already confirmed you have committed a crime. Just like criminals serving a sentence in committee. It's only, they are only lucky that the Senate doesn't jail them. Otherwise, they have now, this is like serving your jail term at home. So it is a form of a judicial process that is exercised by the legislature, and for this matter, the Senate. If the Senate say that, you see, we have to respect our laws. If the governor, for example, doesn't want to go that route, then he should follow the constitution and do the right thing. Because by the time he decided, for example, to give contracts, by the time he decided to appoint or have 36 advisors, 36 advisors for what reason? If a county is a small institution, remember you have around 18 wards in that county of Isiolo. If those 18 wards, then it would have been reasonable to have one advisor per ward, for example. But 36, over 30, what are they, all these advisors doing? And remember, all these advisors are withdrawing from our public coffers a salary at the end of the day. And sometimes some of them just come to the office to sit and take tea. Sometimes some of them even, and we still have the same issue even at the national government, where the president has quite a number of advisors. You find a principal secretary having quite a number of advisors. You find a cabinet secretary having even 2 numbers of PAs. So this calls for accountability. This calls for being true to our constitution, being honest, and deciding to use our resources prudently. The young people are complaining. Our working class are complaining. Our elderly are complaining. And remember, by the time it boils up at the national level, it has started at the grassroots. It's only that sometimes they point a finger at the presidency, but the problem starts from below there. Why can't we have checks and balances? And impeachment is one of the ways of having checks and balances.
Okay, there's also this argument that members of, especially of the Council of Governors, the governors themselves have been making, that some of the county assembly members have been trying to either threaten them or waylay them to reach to a particular point of impeachment. Is that not a valid point?
Now, it depends now with how they will defend themselves, because some are hearsay, some are rumors, and they are not confirmed. And if they have confirmation, they come with the evidence of this is what was happening. But sometimes you find the county, members of the county assembly, perhaps impeaching their governor because they don't listen to them. It's all about listening and consulting them most of the time in doing implementing projects. If at the end of the day you run a show alone in the county, at the end of the day you create enemies even within your friends that were there in the county assembly. And why won't they impeach you? Because if you are not a listening leader, why would you even be in that seat? And therefore anybody can look for anything to impeach you because you don't listen to them. You are elected together. And being a ward representative, I have a say in how my ward is going to be run. And if you run the show in my ward, at the end of the day, you create enmity. So that's why it calls for a consultative leader, an accommodating leader, a tolerant leader. And once you listen, because there are counties that are working, because the governor is working with the members of the county assembly. It is not necessarily about bribing.
Okay, thank you so much. That is Sami Meli. Now quickly, the reason I was cutting Meli short is because the senators have once more converged at the Senate, and there you have it. The members of the Senate as well as the Speaker, that is Jeffa Amason Kingi, are already on the floor of the House. Let me hand you over. And of course, we wait to see what will happen on the floor of the House.
The rules of procedure and other matters pertaining to impeachment. So at any moment from now, the House
in accounting terms that you'd have to, you're accruing. It's accrued.
Reading of the charges on the proposed removal from office by impeachment of Honorable Abdi Hassan Ibrahim, the governor for Isiolo County. Upon the commencement, the charges will be read out before the floor of the Senate this morning, and after that, the governor will be asked to plead guilty or not guilty of the charges that have been leveled against him by the County Assembly of Isiolo. If the governor pleads not guilty, the House commences the hearing of the matter from the both sides of the governor as well as the County Assembly in regards to evidence and witnesses. That aspect will be helping senators to make an informed decision whether the impeachment of the governor for Isiolo County is to be upheld or that decision by the County Assembly of Isiolo will be quashed by the Senate. After the conclusion of the pre-hearing for senators that has just commenced, the House will proceed to the recite of the mandate of the Senate, rules of procedure and hearing of the program, the introduction of the members of the County Assembly of Isiolo representing the County Assembly and their council, as well as the introduction of the governor and his council. The preliminary questions and issues will be raised at this particular point after the reading of the charges. The preliminary issues raised will be determining to whether this matter will be commencing this morning. I gather there are already objections from the side of the governor, 2 of them that are set to be raised this morning. But if the preliminary objections are thrown out, the House will commence with the opening statement from the County Assembly and the opening statements from the side of the governor. Each are allocated 30 minutes before the House commences or proceeds with the hearing of the evidence by the County Assembly, this being the evidence of witnesses before the Senate that the County Assembly will be relying on this morning to convince senators why their case is watertight. A maximum of 5 hours has been allocated for this, with the County Assembly being given 5 or 3 hours maximum. for evidence by witnesses and re-examination. So the County Assembly will have to plan itself within the 3 hours to present witnesses and re-examine them in case that need arises. And within the 5 hours, the Council for the Governor has a maximum of 2 hours for the cross-examination. The charges facing the Governor for Isiolo County are 3 grounds that the County Assembly has or had relied on to impeach the Governor. Among them is a gross violation of the Constitution and other laws, the abuse of office, and gross misconduct. Remember, the Senate, upon the conclusion of this hearing and determination of this matter, towards the end, before the House makes its decision, senators will be voting on the 3 grounds, and 1 charge is enough to take the Governor home. The Governor will require that at least 25 senators do not vote in support of the 3 grounds for his impeachment listed in the motion for impeachment. That way, his political lifeline will be moving on, or he will be saved from the impeachment from the County Assembly. But in the event at least 25 senators vote in support of any of the 3 charges against the Governor, then the Senate will have upheld the impeachment by the County Assembly for Isiolo. The Speaker will make that communication in regards to how the voting will be panning out, and this will be on the final day of the hearing of this matter. Already, the Governor for Isiolo County is in the Senate. You can see on your screens, accompanied by his lawyers, in a bid to defend himself before the Senate. Lawyers Eric Theuri, just close to him, lawyer Elias Mutuma, being the lead counsels for the Governor, and lawyer Elisha. Just to get his name correctly, his name is Elisha Ongoya, being the lead advocate for the side of the Governor. The County Assembly has lined up a battery of lawyers as well. They'll be led by Dr. Ekura Okot, and they are in total 10 lawyers who will be representing the County Assembly and seeking to convince senators to throw out the charges or the impeachment of the Governor for Isiolo by the County Assembly of Isiolo. Remember, Governor Guyo, or Governor Abdi Hassan Ibrahim, if you may like, was impeached by 16 out of 18 members of the County Assembly of Isiolo, and he will be appearing before the Senate. According to the directives by the Speaker, is that both parties, that is the Assembly or the Governor, may appear in person or through advocates, and the other option is appearing in person and with their advocates. So they have opted for the second option, as the Governor is already in the presence of Parliament with his council, as well as the members of the County Assembly. Dr. Ekura Okot is on your screens at the moment, the lead counsel for the defense team leading the County Assembly of Isiolo. And their case here will be seeking to convince senators as to why the Senate should uphold the impeachment of the governor for Isiolo. A number of documents are before the Senate, and these documents will be helping the House to arrive at an objective decision. Remember, the 3 charges facing the governor must be substantiated, where senators will be voting based on their decision whether the 3 grounds or either of the 3 grounds has been substantiated by the county assembly. Allow me to hand you over for this live broadcast. My name is Gladys Mungai. Enjoy your viewing.
Senator Chute and your team, please take your seats. Clerk, you may now proceed to call the first order.
Order number 1, communication from the chair.
Now, honorable senators, ladies and gentlemen, having dispensed with the pre-hearing meeting of the senators, which was a closed session, it is now time to commence the proceedings of the proposed removal from office by impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County. By a letter dated the 27th of June 2025, the Speaker of Isiolo County Assembly informed the Speaker of the Senate that at a sitting of the Isiolo County Assembly held on Thursday, 26th of June 2025, the County Assembly of Isiolo approved a motion for removal from office by impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County. The Speaker of the County Assembly of Isiolo also forwarded the following documents to the Senate, being the record of proceedings of the County Assembly and the evidence adduced in support of the impeachment motion. 1, copy of the approved notice of motion, the motion, dated the 17th of June 2025 and laid on the table of the Assembly on Wednesday, 18th of June 2025 morning sitting. Soft copy of the notice of motion and exhibits contained in the accompanying flash disk. 2, copy of exhibits laid on the table of the Assembly on Wednesday, 18th of June 2025 morning sitting. Video exhibits contained in the accompanying flash disk. 3, order papers for the Assembly sitting of Wednesday, 18th of June 2025 morning sitting and Thursday, the 26th of June 2025 afternoon sitting, and a soft copy of the order papers are contained in the accompanying flash disk. Certified Hansard reports for the Assembly sitting of Wednesday, 18th of June 2025 morning sitting and Thursday, 26th of June 2025 afternoon sitting. Soft copy of the Hansard reports are contained in the accompanying flash disk. Copy of a letter dated 19th of June 2025 notifying the Governor of the notice of motion of removal from office by impeachment. A scanned copy of the letter is contained in the accompanying flash disk. Certified copy of a form for verification of signatures for members in support of the motion for removal of the Isiolo County Governor by impeachment, dated 26th of June 2025, made pursuant to the provisions of Standing Order 65B. A scanned copy of the form is contained in the accompanying flash disk. Certified copy of the roll call vote on the motion of impeachment of the Governor of Isiolo County held during the Assembly sitting of Thursday, 26th of June 2025. A soft copy of the scanned roll roll call vote is contained in the accompanying flash disk. A flash disk 32 GB contained video annexures evidencing the particulars alleged in the motion, as well as a voice adverts on the public participation on the motion run on various radio stations. Pictures and videos of various public participation forums held on Tuesday, 24th of June 2025 contained in the accompanying flash disk. Copy of a public participation report dated the 25th of June 2025 laid on the table of the Assembly on Thursday, 26 June 2025, afternoon sitting, and a scanned copy of the report is contained in the accompanying flash disk. Written/printed memoranda from the different wards and regions submitted to the County Assembly during the public participation exercise on the motion submitted both in support and against the motion. The memorandum includes submissions received via email, minutes, attendance registration sheets, and registration forms for memoranda of the public participation forum held on Tuesday, 24th of June 2025, contained in the accompanying flash disk. And finally, a soft copy of the second edition standing orders of the County Assembly of Isiolo contained in the accompanying flash disk. Honorable Senators, you may walk in and take your seats. Now, pursuant to Section 33(3)(b) of the County Governments Act and Standing Order 81A of the Senate Standing Orders, at a special sitting of the Senate held on Monday, 30th of June 2025, the charges against the Governor of Isiolo County, as contained in the motion of impeachment by the County Assembly of Isiolo, were read to the assembled Senate. Honorable Senators, as you are aware, the mandate of the Senate in relation to the proposed removal by impeachment of a county governor is provided under Article 181 of the Constitution, as read together with Section 33 of the County Governments Act 2012 and Standing Orders 80 of the Senate Standing Orders. In particular, Article 181 of the Constitution provides as follows. 1. A county governor may be removed from office on any of the following grounds. A. Gross violation of the Constitution or any other law. B. Where there are serious reasons for believing that the county governor has committed a crime under national or international law. C. Abuse of office or gross misconduct. Or D. Physical or mental incapacity to perform the functions of office of county governor. 2. Parliament shall enact legislation providing for the procedure for removal of a county governor on any of the grounds mentioned in Clause 1. Section 33 of the County Governments Act 2012, Senate Standing Order 80 and the third schedule to the Senate Standing Orders provide for the procedure to be followed in hearing and determination of the proposed removal from office by impeachment of a governor. Specifically, Section 33(3) and Standing Order 81B of the Senate provide that the Senate may either by resolution appoint a special committee comprising 11 of its members to investigate the matter or investigate the matter in plenary. Honorable Senators will recall that at a special sitting of the Senate held on Monday, 30th of June 2025, the motion for the establishment of a special committee was deemed to have been withdrawn pursuant to Standing Order 70. This paved the way for default position, the hearing of the impeachment charges against the Governor of Isiolo County to be held in plenary. Honorable Senators, by way of status update, pursuant to Rules 4A and 6 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Senate invited the governor to appear and be represented before the Senate during its investigation. The Senate further invited the governor, if he so chooses, to appear before the Senate to file an answer to the charges with the Office of the Clerk of the Senate by 5 p.m. on Friday, 4th of July, 2025, setting out the following. 1. The governor's responses to the particulars of allegations. 2. The mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3. The names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And finally, any other evidence to be relied on. Pursuant to Rules 4B and 7 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Senate notified the County Assembly of the date for the commencement of the investigation and invited the County Assembly to designate members of the County Assembly who shall appear and be represented before the Senate during the investigation. The County Assembly was further invited, if it so chooses to appear before the Senate, to file with the Office of the Clerk of the Senate by 5 p.m. on Friday, 4th of July, 2025, documentation 1, designating the members of the County Assembly, being not more than 3 members, if any, who shall attend and represent the Assembly in the proceedings before the Senate. 2, indicating the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. Number 3, indicating the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And finally, specifying any other evidence to be relied on. On Friday, the 4th of July, 2025, the Office of the Clerk of the Senate received response reference number TW/LIT/027/2025 and dated 4th of July 2025 to the invitation to appear issued to the Governor from Messrs. Theuri Wesonga and company advocates, who indicated that the Governor had appointed the firm to represent him in the hearing before the Senate, and that the Governor would also appear in person and by advocates. The letter also indicated the list of counsel representing the Governor and the list of witnesses for the Governor. Similarly, on the same day, the Office of the Clerk of the Senate received a response reference number 1/CA/1-001/AB/25 and dated 4th of July 2025 to the invitation to appear issued to the County Assembly of Isiolo from Messrs. Alex and Boniface advocates, who indicated that the County Assembly of Isiolo had appointed the firm to represent the County Assembly in the hearing, and that the County Assembly would equally appear in person and by advocates. The letter also indicated the list of counsel representing the County Assembly and the list of witnesses for the County Assembly. Pursuant to Rule 8 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Clerk of the Senate furnished each party with the documentation filed by the other party in accordance with Rule 6 and 7 of the Rules of Procedure. Honorable Senators, the hearing program, which has been appended to today's order paper, detailed the various activities in the hearing and determination of the matter and the time allocated to each activity. It will be crucial that all parties comply with the time allocated. The parties should keep track of the balance of time on each activity displayed through the digital clocks. In summary, the program states that today, Tuesday, the 8th of July, 2025, after we have dispensed with the preliminary matters, the charges against the Governor shall be read. The Governor will be given an opportunity to take a plea on each charge. This will be followed by an opening statement by the County Assembly and thereafter by the Governor. After the conclusion of the opening statements, the presentation of the case of the County Assembly shall commence and shall not exceed 5 hours. At the sitting scheduled for tomorrow, Wednesday, the 9th of July, 2025, honorable senators will be given an opportunity to ask questions or seek clarifications from the County Assembly. Thereafter, the Governor will have an opportunity to present his case before the Senate. The presentation shall also not exceed 5 hours. Honorable senators will also be given an opportunity to ask questions or seek clarifications from the Governor. At the sitting scheduled for Thursday, 10th of July, 2025, the closing statements by the parties will be made for a period not exceeding 1 hour each. The Senate shall then proceed to a debate prior to voting on each of the charges. At this stage, a supplementary order paper will be published to facilitate this debate. In accordance with Section 33(7) of the County Governments Act 2012 and Standing Order 86 of the Senate Standing Orders, the voting shall be by county delegations. The Governor shall cease to hold office if a majority of the county delegations in the Senate vote to uphold any impeachment charge. If, however, the vote in the Senate fails to result in the removal of the Governor, pursuant to Standing Order 87, The Speaker of the Senate shall notify the Speaker of the Isiolo County Assembly accordingly. Now, honorable senators, I now invite counsel for the County Assembly of Isiolo to introduce the legal team of the County Assembly and the members of the County Assembly of Isiolo representing the County Assembly by stating the full name and designation of each person. Counsel, you may proceed. Introductions only.
Thank you very much, Mr. Speaker. The legal team for the County Assembly of Isiolo is comprised as follows: Dr. Ekuru Okot, Mwereru Boniface Mawira, Mwirigi Eric Muriuki, Jamal Abdi Kadir, Chalo Kennedy Maweu, Paul Wafula, Kosgei Alvin Kemboy, Diana Nyaboke, Mugambi Mutua, Hassan Roba, Derek Kombo, Aromo Mariano, and Mr. Speaker, sir, I lead that legal team. The County Assembly is represented by the following members. I'm sorry, my name is Paul Nyamodi. Please excuse me for that. The Assembly is represented by the following members: Honorable Abubakar Abdi Godana, member of the County Assembly of Isiolo; Lematile David Letinina, Lorot Ewaton, Peter Loyan, Aban Kasim, and Abdi Kadir Ibrahim. Thank you very much, Mr. Speaker.
Senator Matinga, take your seat. Honorable Senators, I now similarly invite counsel for the Governor to introduce the legal team representing the Governor by stating the full name and designation of each person. You may proceed, counsel.
Honorable Speaker, on behalf of the Governor of Isiolo, we have the following team of advocates. We have Elisha Ongoya, who is leading the team. My name is Eric Veuri. We have Elias Motuma. We have Tali Israel Tali. We have Marcelino Leisago, Miriam Rebecca Abong, advocate. We have Ms. Ruth Kiunga, advocate. Nura Abdul Kadir, Nura, advocate. Honorable Speaker, we also have Brian Lee Maindi, who is a legal assistant, Brian Gavi, a legal assistant, and Ali Fila, a legal assistant. Honorable Speaker, I believe that we had limited us just to introductions of the advocate. Thank you.
Senator Onyonka, take your seat, please. Now, honorable senators, on behalf of the Senate, I welcome the team for the County Assembly, the team for the Governor, members of public and the media to this Senate and to these proceedings. Finally, I now invite the clerk to call the next order and thereafter read the charges against the Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County. Clerk, you may proceed.
Order number 2, reading of the charges on the proposed removal from office by impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County.
The Honorable Abdi The Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County, please take the stand. Please take the stand. Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County, the charges against you as received from the County Assembly of Isiolo are as follows, and I quote, Ground 1, gross violation of the Constitution and other laws. 1, the Governor has grossly violated Section 30, subsection 2, paragraph K of the County Governments Act by failing to deliver an annual State of the County address for the 3 years that he has been in office. 2, the Governor has grossly violated Articles 201, paragraph D and paragraph E of the Constitution by employing a bloated workforce, including 36 advisors in the office of the Governor, 31 chief officers, yet the county has only 6 departments, and 2 deputy county secretaries whose positions are not known to law. This has created an excessive wage bill that is 46% of the annual revenue allocation, far beyond the 35% limit set by Section 25, subsection 1, paragraph A and paragraph B of the Public Finance Management County Governments Regulations 2015. 3, the Governor has grossly violated Articles 10, paragraph 2, 73, Article 232, and Article 235 of the Constitution, and Sections 59, 59A, 60, and 62 of the County Governments Act 2012 by disregarding the criteria for the establishment of offices within the county public service, by illegally creating offices for advisors and deputy county secretaries without the involvement of the County Public Service Board. 4, the Governor has grossly violated Articles 10, Clause 2, Article 185, and Article 201 of the Constitution by refusing to implement the recommendations and or resolutions of the County Assembly requiring the Governor to control and manage the county public debt in a manner that undermines the authority of the County Assembly, thus resulting in unmitigated accrual of debt to unmanageable levels. 5, the Governor has grossly violated Articles 201, paragraph D and paragraph E of the Constitution by failing to utilize bursary funds in accordance with the approved budget, resulting in a discrepancy of Kenya shillings 30 million, which cannot be accounted for. Ground 2, abuse of office, that the Governor has engaged in acts and omissions which singularly and collectively amount to abuse of office and gross violation of, among others, Article 201 and Article 232 of the Constitution, Sections 8, 9, 10, 11, 12, and 13(1) and 35 of the Leadership and Integrity Act 2012 by the following. A, appointing 36 advisors in the office of the Governor, contrary to the Salaries and Remuneration Commission Circular dated 29th July 2013, the Transition Authority Circular dated 6th September 2013, and subsequent guidelines from the Intergovernmental Relations Technical Committee all of which limit the maximum of advisors to 3. B, appointing 31 chief officers instead of 18, which are provided for in the County Executive Staff Establishment of July 2022, yet the county has only 6 departments. C, appointing chief officers under 2-year contracts, thus creating a climate of fear and uncertainty, which reduces public servants to be servants of the governor and not the people, contrary to Article 73, Clause 1B of the Constitution. The governor failed to renew the contracts of 31 chief officers and instead directed them to hand over to county executive committee members, significantly affecting the continuity of service delivery in the county. And D, appointing 2 deputy county secretaries, which positions are not known to law and are not in the county staff establishment. Ground 3, gross misconduct. The governor has grossly violated 1. Articles 10, Clause 2, Article 27, Article 28, Article 73, Article 75, and Article 232 of the Constitution, and 2. Sections 3, 7, 8, 9, 11, 34, and 52 of the Leadership and Integrity Act. 3. Sections 9, 10, and 21, subsection 2 of the Public Officer Ethics Act 2003. 4. Sections 2, Section 30, subsection 2, and Section 30, subsection 3 of the County Governments Act, by engaging in acts which singularly and collectively amount to gross misconduct by the following. A, making disrespectful, sexist, and demeaning statements against Senator Fatuma Adan Dulo publicly that are only meant to denigrate and degrade her as a woman leader, thus violating her right to dignity. The governor's utterances do not demonstrate respect for the people and other public officers, nor do they bring honor, dignity, or maintain public confidence in the office he holds. The governor's statements amount to gender-based psychological violence and undermine the dignity and the integrity of the governor's office. B, breaching public trust by making divisive, derogative, and discriminatory remarks against other clans residing in the county, thus undermining public confidence in the integrity of his office and sowing discord in the community. And C, being continuously absent from the county and running its affairs remotely from Nairobi, thus stalling service delivery. Honorable Abdi Ibrahim Hassan, how do you plead to the 3 grounds? Ground 1, guilty or not guilty?
I plead not guilty.
Ground 2, guilty or not guilty?
I plead not guilty.
Ground 3, guilty or not guilty?
I plead not guilty.
Next order, clerk.
Order number 3, hearing and determination on the proposed removal from office by impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County.
Now, honorable senators and the parties to these impeachment proceedings, before we embark on the main hearing, Rules 14 of the Rules of Procedure demands that if there are any preliminary issues be raised at this juncture. So if there's any party that has any preliminary issue, this is the moment to raise it.
The Honorable Speaker and the Honorable members of the Senate, we had given an indication to the Honorable Senate that we intend to raise two preliminary issues for the consideration of the Senate. And the issue, Honorable Speaker, is contained in Volume 1 of the document that we filed. In response, we filed several documents, but Volume 1 contains the preliminary issue that we intend to raise. Honorable Speaker, with your leave, I can then quickly delve into that question. The Honorable Speaker, we had noted from the order of proceedings that was supplied by the Senate that this session would take about 1 hour. I propose 2 hours, with 1 hour on our side. I propose to take about 30 minutes or less introducing the first limb of the preliminary issue we intend to raise. Thereafter, my colleague Elisha Ngoya will take 20 minutes, and I will reserve 10 minutes for any rejoinders which will be handled by our colleague, Mr. Elias Mutuma. Mr. Speaker, sir, and honorable members of the Senate, with your permission, we would then move to raise the preliminary question.
So what you're saying is you require 1 hour to effectively move your preliminary issue?
Yes, Mr. Speaker, sir.
Okay. I'll grant you 1 hour, and also I'll grant the County Assembly 1 hour to respond to your preliminary issues. You may proceed, and time starts running from now.
Thank you, Mr. Speaker, sir. The Honorable Speaker and honorable members of the Senate, on the 26th of June 2025, the Speaker of the Isiolo County Assembly issued a press communication at around 3 p.m. announcing that the County Assembly had resolved to impeach the Honorable Abdi Ibrahim Hassan, Governor of the Isiolo County. This communication will be found in Bundle 3 of our volume, that is Volume 3, at pages 2, 3, 4, and 5. This release is significant as it marks, in our view, the announcement of a phantom impeachment of the governor, and we will shortly demonstrate the salient gaps and schemes, and hopefully persuade the Senate to reject this phantom impeachment. The Honorable Speaker and honorable senators, The press release by the Speaker of the Isiolo County Government triggers a very important question, and that is the question upon which our first limb of the preliminary objection stands. What is in law a resolution of the County Assembly? The Isiolo County Assembly Standing Orders, and specifically Standing Order 65-8, provides that when a motion for the removal of the governor is passed by at least 2/3 of all the members of the Assembly, the Speaker shall inform the Speaker of the Senate of that resolution within 2 days. You will find this resolution from the Assembly in the Assembly's volume, that is volume 3, at pages 100. So, Honorable Speaker and Honorable members of the Senate, it is our submission that for the power of the Senate to be invoked under Standing Order 80, the Speaker of the Senate must receive a resolution from the Speaker of the County of Assembly. So therefore, there is a test that is twofold. The first test is that there is a resolution, and the next is that it is supported by 2/3 of the members of the Assembly. Honorable Speaker and honorable members of the Senate, in forwarding this resolution, the Senate Standing Orders, the third schedule of the Standing Orders, and the Senate's Guide Manual on the Procedure and Rules for Removal of County Governments, developed in 2025, require certain documents to be submitted together with the resolution. And that is the impeachment motion, the County Assembly Hansard, the division of voters list, the advertisement of the summons to the governor, the list of witnesses of advocates, the list of advocates, list of witnesses, records and videos, and other evidence. It is our submission that this has a very good purpose. This requirement has a good purpose, and it now fits into the preliminary objection that, or the preliminary issue that we raised. Honorable Speaker and the honorable senators, I will then invite you to examine the documents that were presented alongside the resolution from the Speaker of the Isiolo County Assembly in support of the fact that there was a resolution adopted by the Assembly to remove the governor. I will refer the Senate to the Assembly documents, and that is at volume 3 of the Assembly documents, that is pages 1 to 6, which has the order paper for the 18th, and that order paper ultimately indicates that the motion for the removal of the governor was adjourned to Thursday, the 26th of June, 2025 at 2:30. That time is extremely material to these proceedings. The Hansard for the 18th of June, 2025 at pages 7 to 14, that is still volume 3 of the Assembly documents, indicates that the proceedings for removal of the governor were also adjourned to 26th of June, 2025 at 2:30. At pages 15 and 16, that is still of volume 3, there is an invitation to the governor to attend. That invitation invites the governor to attend the Assembly on the 26th at 9 a.m. Honorable Speaker, Volume 5 of the Assembly's document at pages 3 and 4 contains the affidavit of service of that invitation served by the Speaker. So there is no doubt whatsoever that the Governor is invited to appear at 9 a.m. on the 26th. The Speaker, in Volume 5, also presents a document for the special sitting of the Assembly. It is dated 23rd of June 2025, and that sitting is indicated to commence at 9 a.m. Honorable Speakers and Honorable Senators, it is therefore not in any doubt that the Assembly set the hearing of the motion for the at 9 a.m. 26th of June. I now refer the Honorable Senate to the Isiolo standing orders. Standing order, specifically Standing Order number 1, it is found at Volume 3, pages 85 and 86, on the times set for the sitting of the Assembly, and that is 9 a.m. for Wednesdays and 2:30 for Tuesdays, Wednesdays, and Thursdays. I do not need to say this because you're familiar with these times. It therefore follows that if the Assembly is to meet at any other time other than as set out in the standing orders, there must be a resolution to that effect. And so, therefore, the logical question that we are asking the Senate is this: is the Hansard genuine? Because the Hansard talks about a sitting conducted at 2:30 p.m. That is in line with the standing orders. But the notices, the invitation, and the special sitting issued by the Speaker talk about a sitting to be conducted at 9 a.m. So therefore, Honorable Speaker and Honorable Senators, we invite you, the Senate, to take note of the above, and then allow us to also review the Hansard that is provided. You probably understand the Hansard much better than we do, and I refer you to the Hansard for the 18th of June 2025, which clearly shows that the Assembly was adjourned to 26th of June at 2:30 p.m., and I refer you to Volume 3 still of the Assembly's documentation. The issues that you will note when you review the answer is that, first of all, it is not certified by the clerk as is required. It just bears a stamp. It is therefore our submission that these latent, open, obvious, and blatant contradictions and anomalies between the Hansard and other records provided by the Assembly are major indicators not only of misrepresentation, but that the documents presented by the Assembly have been cooked and generated outside of the Assembly. This is further supported by the testimonies of the witnesses, which will be found at Volume 2 of the Governor's response at page 14, where we have the affidavit of Salad Boru Gurasha, who was the clerk of the Assembly, who confirms that there was no sitting of the Assembly on either date. There is an affidavit by the Leader of Majority, Diba Ali, at pages 41 to pages 45, who confirms there was no sitting of the House Business Committee to deliberate and set out the order papers. Further, we have the affidavit of Shaban Mzungu, who was in charge of security at the assembly on that particular day, and he confirms that there was no sitting of the assembly. Honorable speakers and honorable senators, we expect that the assembly will try to persuade you that the issues we raise are not preliminary and they require a full evidential hearing. But allow me, honorable speaker and honorable members of the Senate, to refer you to the assembly's submissions on the preliminary objection, because they have filed submissions on the preliminary objection and they have quoted a decision. And the jurisprudence from the courts is that a preliminary question is determined on the presumption that the facts pleaded are true. The facts that we are raising are the facts that have been pleaded by the assembly. And that preliminary issue, when determined, may as well as dispose of the suit, and it is for that reason that we raise it as a preliminary issue, because if this Honorable House was to find that there was no sitting of the assembly, then we cannot proceed with the hearing of the impeachment motion. And so we submit that these questions that we have raised satisfy this threshold, and we invite the Senate to look at the facts that have been pleaded by the assembly and the documents that have been provided, and agree with us that this is a case of a phantom impeachment. Finally, as I, with one eye on the clock, we submit that this process is a hallowed process. It is not just about whether the grounds set out in Article 181 of the Constitution have been met. If the Senate is to examine whether there was a valid resolution and agree with us that the documents that have been presented are forged and cooked, then this impeachment, this phantom impeachment, amounts to an affront on the Constitution, and it sets a very dangerous precedent, because what it means is that it is possible for the Speaker and a few members of a rogue assembly to, in a way, attempt a coup, sit somewhere, cook documents, and present it to the Senate, and the Senate will then hear that matter. That in itself will be a violation of the Constitution, because this Senate has a mandate to protect devolution and to protect the counties. And that is the danger that we face in these phantom impeachment proceedings. Honorable Senators, the impeachment proceedings not only put the governor on trial, it does the same for the Constitution. It does the same for the Senate, for the members of the county assembly, for the witnesses, for the lawyers on either side, and ultimately the Kenyan people. It is our humble submission that the Kenyan people vested the power of impeachment in the Senate because they expected that the senators had special qualities, numbers, and temperament to rise to the occasion, and we urge this House to rise to that occasion. Finally, before I cede ground to my fellow counsel, allow me, Honorable Speaker and Honorable Senators, to just remind you of the words of Alexander Hamilton, one of the founders of the American Constitution, on the power and the question of impeachment. Hamilton explained that the senators were seen as the ideal arbiters in an impeachment process because the Senate would be a tribunal sufficiently dignified and sufficiently independent of the actual interest aligned in the subject of an impeachment. We urge this House to rise to this occasion, and we respectively urge the Senate to review the material that we have provided and to find that there was no sitting of the Assembly that gave rise to the resolution that is before you for consideration. And Honorable Speaker and the Honorable Senators, I thank you for the opportunity you have accorded us to address you on this issue, and I invite my senior Elisha Ngoya to take us on the second limb of our preliminary issue.
Thank you so much, Mr. Speaker, and thank you, distinguished senators. As indicated, my name is Elisha Ngoya, lead counsel for the governor. Before I address you on another substantive preliminary question on an existing court order touching on these matters, allow me to invite my learned colleague, Mr. Elias Mutuma, to wind up on that issue of the proceedings before the Assembly by drawing your attention to certain salient material aspects of the purported Hansards that have been presented before you, so that you have all that in consideration. Then I'll move to the next subject. Thank you so much, Mr. Speaker.
Thank you, Mr. Speaker, sir, honorable senators, for the opportunity. The council representing the County Assembly will be here shortly to try and convince you that what we have raised is not a preliminary objection, but requires an interrogation by way of listening to witnesses and making a determination based on what they will say. But our submission is simple, honorable senators, that what we have raised is a pure PO that can be addressed and determined based on what has been presented by the County Assembly of Isiolo. Honorable senators, my understanding of Hansard's records is that they are a verbatim record of what transpires in a House proceedings. Therefore, they are able to tell us exactly what happened on the day that that motion is said to have been passed. We have raised an issue with proceedings that are said to have taken place on the 18th of June 2025 and proceedings that are said to have taken place on 26th of June 2025. Honorable senators, with your kind permission, kindly hold your volume 3 of the County Assembly's documents. I will take a very short time to take you through the Hansards, and this being a house that is also a house that is very much familiar with proceedings in the House, you'll be able to tell me whether there is anything that took place there. At page 7 of that bundle, we have been presented with what is said to be the proceedings of 18th of June 2025. Page 7 of Saba 7 of volume 3 of the documents. Page 7. We see the House purportedly sitting for the first time. There is no communication from the chair. There is no calling of orders by the clerk. Straight away, the mover of the motion proceeds to execute the business of the day. Look at it. It is straight away withdrawal of the motion on the impeachment of Isiolo County Government dated 10th June 2025. What does it begin with? Honorable Abubakar Godana. Honorable senators, who presided over this session? There is no invitation from the Speaker for the mover of the motion to proceed and execute the business of the day. Let's proceed. Honorable Abubakar Godana proceeds and proposes a motion to withdraw the previous motion and invites two members of the County Assembly, Honorable Nicholas Lorot and David Nyoro, to second the motion. Without again the intervention of the Speaker, these two members rise and they proceed to second the motion. So who invites them to the floor? Who is presiding over this House? Let's go on. The two members support the withdrawal of the motion, and the Speaker now is seen for the very first time. There is no question put to the members. There is no vote that has taken place, but the Speaker proceeds to say, the members, the notice of the special motion or the removal from office by impeachment, the Governor of Isiolo County issued on Tuesday, 10th June 2025, has been officially removed as requested by the mover, Honorable Bakar, member for Sericho Ward. We now proceed to the next business. So who approved this withdrawal? Who approved this withdrawal? Where is the vote? Let's proceed. Honorable Senators, we proceed to the Hansard now of 26 when the Governor is being purportedly impeached. That's at page 23 of the same document. There is a communication from the chair. The first order of business, you will come across the order paper at page 17, where we have a total of 8 orders of the day. 8. But when you go to page 23, we do not see the clerk calling out the orders. Just look at it. It is the Speaker directly proceeding to make a communication. Is that an anomaly, Honorable Senators? We are all familiar with the business of the day. But what intrigues me more, Honorable Senators, the first order of the day here is to lay on the table the purported public participation report, which is done by Honorable David Lemantile, allegedly. He prosecutes his motion and argues on the public participation. Let's go to the end at page 31. But before that one, let's go slightly at page 30, where he completes his submissions. After laying the paper, public participation, we now see Honorable Peter Losu standing up to second this motion. Who has invited him to second this motion? Out of nowhere, he's not invited by anyone, but Hansards show that he rose to second this motion. And then the Speaker proposes the question and it opens the floor to the members of the House. At page 31, the last member seen to be speaking is Honorable Francis Letimalo. The Speaker now puts the question. So what happens after the question was put, Honorable Senators? There is no record whatsoever of what transpired. Nothing. A question is put, there is no indication that the House actually endorsed the public participation report. That Hansard is left hanging. Honorable Senators, after that paper is laid, the Speaker does not even call for the next order. The clerk is not seen anywhere calling for the next order. Instead, what do we see? Honorable Abubakar Godana is seen now on the floor. Answers are supposed to be capturing verbatim what transpires. So who was in charge of this house? Where is the speaker's recording inviting the mover of the motion to move the motion? Where is the recording of the clerk inviting, or rather calling for the order, for the next order? There is nothing. Instead, we just see someone on the floor prosecuting the motion. And he proceeds and proceeds. At page 35, he's done. Strangely, the first paragraph at the top of page 35, when he completes to execute his motion, he does not invite anyone to even second. Records are there. But we see one Honorable Major Golicha now standing up to second the impeachment motion. Who has invited him? There is no one. And other members, strangely now, so the House is suddenly in an autopilot. So from Honorable Major, then we see the Speaker opening the floor. You have Honorable Peter Losu. He continues. Without the intervention of the Speaker, there is another member, Honorable Salesio Kiambi, who proceeds as if the Speaker is not in this House, as if the clerk is not in this House, and proceeds. Another member just rises up from nowhere. There is no recording of the Speaker inviting any member to make a contribution to this motion. Apart from, of course, page 39, when suddenly the person cooking this answer realizes the Speaker has not been captured in this, and now we see the Speaker for the first time. In conclusion, because I do not want to take time that my senior is going to take to address you on the other issue, look at page 41. After the members purportedly complete to make their submissions, the Speaker makes very strange remarks, and I quote at page 41. Clerk, is the governor or his legal representative available? Sergeant at Arm, can you check around if the governor or his legal representative are present? The Speaker does not even take time to communicate to the House whether the governor had been invited. He does not even read that invitation notice as required. So why is he calling for the governor, whom Learned Counsel had told you was invited to appear at 9 and we at 2 o'clock? The Speaker is not seen anywhere saying that we invited the governor by this letter and he has not come, but instead asked the clerk to check whether the governor is available anywhere. Let's proceed. I'm completing, honorable senators, and this is going to shock you. So, when the governor was confirmed was not in the House, the Speaker proceeds to guide the House on the next move. At the end of that page, 41, I read what the Speaker says. When the doors, I'm reading the last part, when the doors have been locked and the bar drawn and the names of the tellers have been announced, the Speaker shall, this is the Speaker telling them, the Speaker shall put the question again in the presence of the tellers. When called out, each member shall thereupon rise in his or her place and declare assent or dissent to the question in the following manner. I vote yes or I vote nay. Proceeds. Honorable Senators, page 42. Where does the Speaker put that question to the members of the House present? There is no question put whatsoever. She has just told them that he needs to put that question again. There is no question put. So what were these members voting for or against? There is no question put. Honorable Senators, we then need to sit here and invite witnesses on the stand to demonstrate that there was no proceedings that took place on 26th and 18th. I rest my case.
Thank you, Mr. Speaker, and thank you, distinguished senators. I'll proceed to argue the final limb of the objection, but just to cap up what my learned colleagues have told you, that if before you is a purported Hansard in the form and content that you have been taken through, if before you is a purported Hansard that no one has taken the courage of his or her conviction to certify, if somebody brought before this House a Hansard that is not certified, because certification is done by a particular officer whose signature we can tell, is what is before you a Hansard of the County Assembly of Isiolo or a mere piece of paper? And if we conclude, as I invite you to, that what is before you is a mere piece of paper, to the extent that it is not certified, can we take any other proceedings on the strength of that mere piece of paper? That is what makes this issue a proper preliminary objection for resolution, one way or the other, before we can go into the trial. Secondly, is the issue of the order of court. And I want to address this issue as follows. We are guided by the Constitution and other laws and the standing orders, and to an extent, the manuals that this House publishes from time to time to inform both these members and the members of the public who interact with this House. My research has revealed that the latest manual issued by this House is a manual entitled Removal from Office of County Governors and Deputy County Governors through Impeachment, an easy-to-use manual on the procedures and rules. That manual, on the face of it, was published by the Directorate of Legal Services and the Senate Liaison Office in the year 2025, which is this year. Part 3 of that manual is entitled Judicial Proceedings Against Impeachment. And this is the position this House has communicated in that manual at page 60, which is the very last page of that manual. There are 2 subtitles at page 60 of that manual, which is subtitle 1, Comply with Court Orders. And it says, parliamentary privilege and immunity and the principle of separation of powers do not shield the county assemblies and the Senate from court orders. When court orders are issued, they are binding on the county assembly and the Senate and must be complied with. Failure to comply with court orders may result in the invalidation of the entire process of impeachment by the courts. Then the second subtitle is participate actively in court proceedings, and this Senate has communicated to us through this manual that ignoring court orders against the county assembly or the Senate is not the solution. If court orders are issued against a county assembly or Senate, the most preferable option is to participate actively in the court proceedings. The county assembly or Senate may apply for review of the court orders or appeal to the next court for variation or the setting aside of the court orders. That is the manual that this House has published as late as this year. Allow me to make the following submissions then. The existence of the orders of court I am going to refer to is not a disputed fact. It is a fact admitted by the county assembly in their written submissions. So the existence of these orders is not a contested issue. And it not being a contested issue, it follows therefore that this Senate can proceed right away to resolve the question of the impact of those orders without investigating whether they exist or they don't exist, because between the parties, it is an admitted fact. Allow me to begin by referring this order, this Senate, my apologies, to an earlier ruling of the Speaker of the then only House of Parliament, which was the National Assembly, before the new constitution. This was the ruling by Speaker Kenneth Otiato Marende on the question of nominations of Chief Justice, Attorney General, Director of Public Prosecutions, and Controller of Budget, and that ruling was made on the 17th of February 2011. It is found in volume number 4 of the governor's documents. It is found in volume number 4 of the governor's documents, and you'll find that ruling starting at page 165 of volume number 4 of the governor's documents. But the relevant part I will refer to in the interest of time is at page 168 of that volume, volume number 4 of the governor's response. At page 168 is a continuation of that ruling of the then Speaker of the National Assembly, Honorable Kenneth Otiato Marende. He says, and I quote, "Honorable members, between the time when Mr. Imanyara first raised the matter and now, I have had the benefit of considering a range of material addressing the various aspects of the matter. Specifically, I have benefited from, among others, the position taken by the Judicial Service Commission, the Commission on Implementation of the Constitution, and the Law Society of Kenya. I have also carefully read and considered the ruling of the High Court relating to the matter of nominations, which was delivered on 3rd February 2011. Mr. Speaker, distinguished senators, I had the rare privilege of participating in that court proceeding. The first three of these bodies are constitutional or statutory, and their views on matters of law, though not binding to this House, are of significant persuasive value. Honorable members, as for the ruling of the High Court, despite my restatement of the constitutional relationship between the legislature and the judiciary, I have repeatedly emphasized that subsisting judicial decisions, while they cannot restrain the legislature, and that's important to us because I'm addressing this issue, while they cannot restrain the legislature from the discharge of its functions, are of binding effect and may have a bearing on the products emanating from this House. The learned Honorable Justice Musinga, in his ruling in the above case, found that the nomination of the Chief Justice was unconstitutional, for it was not in accordance with Article 166 of the Constitution. I'll then proceed to page 169 of that volume in the interest of time. The paragraph starting with honorable members, that will be the third paragraph. Although I have read that this court decision does not stop the National Assembly from proceeding with its work and cannot determine for the House how to proceed, it must be noted, as matters currently stand, any decision made by this House on the nomination, though perfectly procedural from the point of view of the legislature, outside the legislature, it is, to the extent that it does not accord with the ruling of the court, null and void for all purposes. So that is the guidance that Honorable Marende makes. Allow me to then come to the specific ruling that we wish to draw this Senate's attention to, and that I will refer you to volume number 4 still. Thank you so much, Mr. Speaker. And as somebody who has been here multiple times, I'm always impressed by the support we get from the administrative teams in this Senate. That may have to go on record in the interest of posterity. At page 13 of volume number 4 is a decision of the court in Isiolo High Court Constitutional Petition number A004 of 2025. The parties are Honorable Abdi Ibrahim Hassan, the governor now before you, as petitioner, and the County Assembly of Isiolo, now before you as the first respondent. There are two other parties in that matter, but safe to highlight that the parties before you are parties in that suit. They are therefore bound by the decision of that court. At page number 25, allow me to just go straight, Mr. Speaker, to page number 27. You'll find a paragraph 28 of that ruling. And the judge observes as follows: it is important to note that there was no complaint raised when the first orders were issued by the court in respect of the motion dated 10th June 2025 that was to be debated on 17th June 2025. In fact, the sentiments by the mover of that motion, the contemnor, actually vindicates the court, as he has in his affidavit conceded that the motion was defective in substance and marred with procedural irregularities, the very grounds that the petitioner has sought to rely on. The mover of this motion went to court and told the court, it is true that the orders you gave first were right, because the motion I had tabled was marred. It was defective in substance and marred with procedural irregularities. The move of the motion. Allow me to then take you to paragraphs 45, 46, and 47 of that ruling at page number 35 of volume number 4. Paragraph 45, the judge says, therefore, it is the finding of this court that the motion dated 18th June 2025 and debated by the first respondent on 26th June 2025 was in contravention of the conservatory orders of this court issued on 25th June 2025. Hence, the resolution arising therefrom is null and void. Once an act is declared null and void, it is of no legal consequence. A court of law has found that this motion, which has now been brought here before you, senators, is null and void. It is of no legal consequence. Paragraph 46. As stated, the resolution has evidently been submitted to the Speaker of the Senate. It is thus upon the Senate, once informed of the orders herein, which I'm now doing, Mr. Speaker, distinguished senators, to determine if it will proceed to handle the said resolution, thus abating a blatant disregard of the rule of law or the respect of orders. The matter at hand calls for a stand to be taken by the constitutional organs involved. What they choose to do will have set a precedent on the necessity for compliance with court orders. It is a choice between anarchy and constitutionalism. Distinguished senators, the judge is saying this. The judge is saying, I am aware. I cannot stop you from doing your work. So he's saying, proceed and go to Senate. And that, to my mind, was an extremely wise move by the judge, considering historical pleas for there to be institutional committee between institutions and to respect the powers of each organ. But the judge is saying, so you decide for yourselves how you will proceed. I have made a finding that that motion is null and void and of no effect. I want to contradistinguish this with other scenarios that the other side will draw your attention to shortly. The judge has not issued a conservatory order against this Senate. The judge has made a determination on the validity of the motion purportedly debated and purportedly approved by the County Assembly of Isiolo. The judge has made a determination. It is null and void and of no legal consequence. You are being invited to engage with this motion on that strength of fact, on the strength of the finding by the judge that the motion as approved, as brought before you, is null and void and of no legal effect. We therefore invite you to introspect and make this determination. When the impeachment law calls upon you to determine a motion that has been approved by the county assembly, is it just any motion or a valid motion? If there is information before you that the motion is invalid for any reason, what is the precedent that has been set by this Senate? It is against that background that I wish to draw this Senate's attention to its resolution that is found from pages 136 of volume 4 of the governor's documents. And this was the determination of the proposed removal from office by impeachment of the governor of Kericho County, Honorable Dr. Eric Kipkoech Mutai. On that occasion, the validity of the resolution was questioned on the ground that the motion had not met the threshold. And rightly, this House found that it could not move a step further because validity of the motion is an important precondition to the carrying out of the trial process on the motion. Similarly, by parity of reasoning, today, validity of another motion has been impugned on two grounds. One, there was no sitting known to law of the County Assembly of Isiolo to approve the motion. And number two, in any event, a court of competent jurisdiction has made a finding that whatever came from the County Assembly of Isiolo is null and void and of no legal consequences. Will you, in the face of the precedents you have set by previous speakers' rulings and by resolution in the case of Kericho County Governor's case, proceed to trial on that understanding? We beseech you with humility to find that there is no motion known to law before you and thereby to down your tools. I humbly submit and respect and rest the governor's submissions on that question of the preliminary objections. I reserve our 10 minutes, Mr. Speaker, for a rebuttal from this side once the County Assembly has finished their response. Thank you so much, Mr. Speaker. Thank you, Senators.
Counsel for the County Assembly.
Mr. Speaker, I will respond to the arguments that have been made by my learned colleagues for the governor, and I am the only member of the team for the Assembly that will respond to those preliminary issues. Mr. Speaker, I am grateful for the opportunity to respond to those preliminary issues. I shall constrain myself to the time that Mr. Speaker has gladly extended our way. Mr. Speaker, I wish to start my response to those preliminary issues by stating that a preliminary issue, by definition, must be an issue that goes to the ability of this House to entertain the motion before it. It cannot be an issue that is merely important to the governor. It cannot be an issue that is merely important to the governor. Sorry, I cannot see my time. Thank you very much. It cannot be an issue that is merely important to the governor, and the governor then chooses to bring it forward and deal with it as a preliminary issue and it does not go to the ability of this House to hear the motion before it. And, Mr. Speaker, it is settled that a preliminary issue assumes that the facts are settled. Mr. Speaker, the consideration of what the Governor's Council purports to be a preliminary issue involves the detailed consideration of evidence. I was constrained to stand up on my feet and object whilst my learned colleagues were on their feet, because it was apparent that what my learned colleagues were doing for the Governor was leading evidence. They were testifying. They were referring to contested statements in the bundles of both documents, and there are responses from the County Assembly in respect of those statements. And those statements must be tested by way of cross-examination. And only once the evidence is laid before this House and it is tested, like the Assembly is entitled to do, then can this House make up their minds as to whether or not those issues hold any water. I am not saying that this House should not consider those issues, but what I am saying emphatically is that this House should not consider those issues as issues that are preliminary to the determination of the motion. There are issues in the motion, and I will demonstrate in a moment how those issues are indeed issues in the motion. I will choose, or I have chosen to respond to the issues that were argued by my learned colleagues for the Governor, using a slightly different framework from what they did. We distilled 3 or 4 issues from the notice of preliminary objection that was served on the Assembly, and I wish to crystallize the first issue I wish to respond to as follows, Mr. Speaker. That the Governor challenges the validity of the impeachment motion in light of the declaration by the High Court of Kenya sitting in Meru that the impeachment proceedings are a nullity. It is correct, as was submitted by Mr. Ongoya, that it is not contested that indeed there are orders that were issued by the High Court of Kenya sitting in Meru in respect of these proceedings. But what is contested, and I doubt we will agree on this, is the effect of those orders on these proceedings. Mr. Ongoya and his colleagues say that the effect of those orders on these proceedings is to invalidate them, and this Senate should therefore down its tools. We disagree. I submit, and I wish to submit, Mr. Speaker, and emphasize that elections to offices, such as those occupied by the members of this House, are conducted by the people of Kenya in furtherance of primordial sovereignty. Mr. Speaker, the exercise of removal of an elected official, such as the removal of a governor, is therefore, in my submission, the flip side of that exercise of primordial sovereignty. And as authority to my submission, I wish to refer, Mr. Speaker and members of this House, to the provisions of Article 1 of the Constitution. Mr. Speaker, Article 1 of the Constitution provides as follows at Article 1.1. It states that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this Constitution. That is an affirmation of sovereignty by the people of Kenya, and it is clear where the sovereignty lies. Article 1.2 then goes on to say that the people may exercise the sovereign power either directly or through their democratically elected representatives. The important provision of Article 1, which I wish to emphasize, is the next provision. Mr. Speaker, sovereign power under this Constitution is delegated to the following state organs, which shall perform their functions in accordance with this Constitution: Parliament and the legislative assemblies Parliament and the legislative assemblies in county governments, the national executive and the executive structures in county governments, the judiciary and independent tribunals. Mr. Speaker, the function of the removal of the governor is delegated to the Senate of the Republic of Kenya by virtue of Article 1.3. The election of the members of parliament, members of the National Assembly, members of the National Assembly, members of this Senate, and any elected office is done directly by the people of Kenya. Mr. Speaker, as I have said, impeachment is the flip side of election, and it is done again here by the people's representatives. And here I wish to emphasize this point. Mr. Speaker gave a correct and appropriate direction at the beginning of these proceedings, that voting on this motion is by delegation. Voting on this motion is not by all members of the Senate, but it is by delegation. And I submit that that is in recognition of the special role, the special function that this House is being called upon to perform when you sit to consider the motion for impeachment. It is not legislative, but it is delegated, and the House has correctly interpreted that role as being exercisable only by delegations and not by all members. Mr. Speaker, it is my submission that a correct interpretation of the doctrine of separation of powers is as follows. Mr. Speaker, and it has been held not just by this House and not just by the High Court, the Court of Appeal, and the Supreme Court, that the role of the judiciary in examining impeachment proceedings arises or kicks in once the impeachment proceeding is complete. Yes, the judiciary has a role, but the judiciary then, as has been correctly held, does not have the ability to intervene at every stage. In our written submissions, Mr. Speaker, we have referred you to the relevant decisions of the Court of Appeal. We have referred you to the decision of the Court of Appeal in Kawira Mwangaza and the decision of the Supreme Court rendered earlier in the matter of Martin Nyaga Wambora. And I wish to suggest a reasoning, perhaps, why the law is as it is. Impeachment proceedings and many proceedings under our Constitution are time-bound. And if judicial intervention is allowed in some of these time-bound proceedings as they proceed, it is not clear whether the judiciary has the ability to suspend constitutional time so as to allow the judicial proceedings to proceed, or whether it is better off to allow the impeachment proceeding to proceed and be completed. And then what is taken is a process review of a completed proceeding to court. What am I saying? The correct interpretation of the doctrine of separation of powers, and it has been held repeatedly by this court, by this Senate, and by the courts, is that even where an impeaching assembly is making a mistake, allow it to complete the mistake. And what is then justiciable is the completed mistake. Don't interfere in between because of timelines, and that, I submit, is a modern interpretation of the view of the doctrine of separation of powers as to how it applies to the power of legislative assemblies, county assemblies, and this House to carry out their function of impeachment. Mr. Speaker, there was reference to a decision that was made by Kenneth Marende when he was Speaker. And it was a decision in respect to the appointment of the Honorable the Chief Justice of this Republic. And I wish to distinguish that decision from the matter that is before you for this important reason. Mr. Speaker, I have stated, and I will take your permission to emphasize, that impeachment are time-bound proceedings. The appointment of the Honorable the Chief Justice, yes, was a constitutional process, but it had no time limit. And the process of that appointment had the luxury of time. It could take as long as it needed to take, and it then made room in it for judicial interventions during the process of the appointment of the Honorable the Chief Justice. I have stated, and I will emphasize, that impeachment proceedings are time-bound proceedings. And if they are not concluded in time, we would then be faced with the ridiculous situation where somebody runs to court and say that Assembly X or the Senate of the Republic of Kenya did not complete their mandate in time. And I believe I was seated here a few months ago when the impeachment proceedings of the Deputy President of the Republic of Kenya were being conducted. And that was an important consideration, the strict timeline that guided many of the directions that, Mr. Speaker, you made during those proceedings. I urge you to call on that wisdom and to find, if you are persuaded to consider this as a preliminary issue, that because of the strict nature of the timelines, then the room for court or the role for court is ex post facto considerations of completed processes of impeachment. Mr. Speaker, there is a decision that has been referred to, and it is a decision that we advocates all know, and I'm glad, Mr. Speaker, you are an advocate, and I'm sure you are familiar with this decision. It is a decision that is referred to in the submissions by the governor, and that is the decision of Lord Denning in the famous case of McFoy versus United Africa Company, where they seek to persuade, and in citing that decision, counsel for the governor seek to persuade you that because the proceedings are a nullity, then you should not proceed any further with these impeachment proceedings. I wish to rely on that decision, Mr. Speaker, and I wish to rely on that decision in an attempt to persuade you that it is indeed the proceedings before the High Court of Kenya in Meru that were a nullity, coming as they did, contrary to the established law and contrary to the established interpretation of the modern doctrine of separation of powers, prior to the completion of the impeachment proceedings. Those or that decision or references to that decision are a nullity, and you should disregard that decision and proceed. Mr. Speaker, I heard a few passages from the decision, and learned counsel for the governor seemed to be suggesting that the judge of the High Court in some way may have been directing this House as to what to do with its orders. I submit that this House is completely independent under the Constitution of the Republic of Kenya, and you should be guided properly as you then consider this preliminary issue. But in conclusion, I wish to state that this preliminary issue is not a preliminary issue. It is based on contested issues of fact, which we should then get the opportunity to look into. The second issue that I wish to respond to is an issue that when I first encountered it, I was a little concerned. And that is the submission that has been made by my learned colleagues for the governor, and they have taken some time on it, that there were no sittings of the County Assembly of Isiolo on the 18th and the 26th of June 2025. They have used that submission in support of several grounds of their PO, and I wish to respond to that ground, and I wish to ask the House to apply it to all instances where they have made reference to the fact that indeed there were no sittings on the 18th and the 26th of June 2025. I wish to submit that that argument, with tremendous respect to the governor and his team, is self-defeating. And it is a self-defeating argument if you look at it from this perspective. Mr. Speaker, it is the proceedings of the County Assembly of Isiolo of the 18th and the 26th of June 2025 that the governor has taken to the High Court in Meru, and it has resulted in the decision of Mr. Justice Nyaga sitting in the High Court in Meru, which is set out, the order arising from Mr. Justice's decision is on, Mr. Justice Nyaga's decision, is on page 6 and 7 of volume 3 of the governor's document. And the ruling itself is to be found between pages 13 and pages 37 of volume 4. And having based substantive legal proceedings on the proceedings of the County Assembly of the 18th and the 26th of June 2025, it then cannot fall from the governor's mouth to come here before you this morning and assert that there were no proceedings. They have based substantive legal proceedings on the fact that there were proceedings. They have gotten certain orders from the High Court in Meru, which orders they seek to bring before you and urge you to declare the proceedings a nullity. I submit that they cannot. and for the completeness of the record, I submit that an estoppel arises against them approbating and reprobating in the manner in which they do. And an estoppel, for the purposes of my submission, is a legal principle which precludes a person from asserting something contrary to their previous action or statement. The contrary provision is that there were no proceedings. The previous action is that they took those proceedings to the High Court, persuaded the judge of the High Court that there were proceedings, and obtained orders. They cannot do both. And for that reason, I urge you, I submit that that ground of the PO must fail. There is the issue that my good and learned friend, Mr. Theori, commenced with, and I wish to crystallize that issue as the threshold issue. The short and sharp answer to the threshold issue is that threshold, the determination of whether or not a motion surpasses the threshold required in law requires the consideration of testimony of evidence from both sides. And the consideration of evidence must of necessity, Mr. Speaker, include the testing of that evidence. There are witnesses that the governor has brought, and there are witnesses that the governor has brought and their testimony was referred to in support of this submission. We, as the advocates who are present for the county assembly, wish to test that testimony. We do not believe that what has been stated in those statements is correct. Those facts, Mr. Speaker, are therefore contested. And if they are contested facts, they then cannot form the basis in law or otherwise for a preliminary issue. That must go on to full trial, and in the context of these proceedings, that means the hearing of the motion that has been brought. Mr. Speaker, one of the reasons that the governor gave for in support of the submission that the threshold has not been surpassed was the fact that the minutes in support of those, the Hansard, sorry, not the minutes, Mr. Speaker, in support of those two proceedings were not signed. That one of the governor's witnesses is the clerk of the assembly, the county assembly of Isiolo. Most unusual in the circumstances, because it is the clerk's responsibility to sign those Hansard proceedings. We look forward to the opportunity, Mr. Speaker, to test the testimony of the clerk and get the clerk's explanation. And we believe this House explanation from the clerk, the responsibility of certifying to his explanation those minutes. The clerk he has put in a witness statement or an affidavit, and we wish to test his testimony. Mr. Speaker, it is my submission that with the facts contested as they are, it is then difficult to use those facts to then make a determination on the preliminary issue. The next issue that I wish to submit on and emphasize is that the material that the governor wishes to rely on for his preliminary issue is the same material that the governor has brought forward or has brought or seeks to rely on as testimony in opposition to this motion. Mr. Speaker, members of the House, I wish to refer you now to Volume 2 of the governor's response to the motion that is before you. And in Volume 2, there is the statement at page 24, and this statement runs all the way to page 32 of one Salad Buro Guracha. Salad Buro Guracha is the clerk of the County Assembly of Isiolo. As I have said, in a most unusual way, he is a witness for the governor. he makes certain averments in that affidavit which we need to test. Those averments have been repeated by other witnesses, and it is those averments that have been relied on by my learned colleagues on the other side in support of their assertion that there is indeed a preliminary issue that requires consideration and needs to be determined as a preliminary issue. Mr. Speaker, I wish to cede the remainder of our time to my colleague, Mr. Mawira, but as I take my seat, Mr. Speaker, I wish to make the following suggestion. Mr. Speaker, it is apparent in a rather blatant manner that the issues that have been brought as preliminary issues before you are not preliminary issues, whereas they may be issues that are fit and proper for the determination of this House, but they are not fit and proper for determination as POs. My suggestion, Mr. Speaker, is that the PO be dismissed and that the governor has an opportunity then to ventilate those issues in his evidence in opposition to the motion, and that this House then makes a determination on those issues once it has had the benefit of hearing testimony from both sides, and both sides have had an opportunity to test that testimony. How much of that?
Honorable Speaker, my name is Mawira. I'll take the remaining time to address the submissions that have been made by my learned senior. Foremost, Honorable Speaker and members of this House, it is not contested that there is no order, there is no conservatory order stopping Senate from considering the impeachment motion that is before you. There is no order by court injuncting or enjoining this House not to proceed with the business of the day. What the governor challenges or impugns is the validity or otherwise of the impeachment motion that is before you. I submit, Honorable Speaker, that the question of validity of the impeachment motion is a question of interpretation and is reserved for the judicial arm or branch of government at the opportune time. As my learned senior, Nyamoji, has already submitted, we have authorities in the submission that we filed in response, and this Honorable House has given rulings in previous matters, including the previous ruling in the impeachment, in the matter of the impeachment of the governor of Kericho County, that legislative processes that are before Parliament, the moment this House or Parliament is seized with a resolution by a county assembly to remove the governor from office, this House becomes irreversibly seized of that impeachment motion, and no order of court can stop this Honorable House from conducting its business. More importantly, Honorable Speaker, that position has been adopted not only by this Senate or this Parliament, but by other parliaments world over. We have authority in the report of the committee on the proposed removal from office of the governor of Embu County that the Senate becomes irreversibly seized of the matter the moment the Speaker of the Senate receives a letter from the Speaker of the County Assembly communicating the resolution of the Assembly to remove the governor from office. The committee went ahead, Honorable Speaker, to quote similar positions adopted by parliaments in other jurisdictions, including Ghana, in the Supreme Court of the decision there, Honorable Speaker, Sri Lanka, and the United States. Honorable Speaker, the position that has been taken by this House in previous impeachment proceedings has been adopted by the highest courts in the Republic. The Supreme Court, in the matter of the governor of the former governor of Embu County, Martin Jaga Wambora, and the Court of Appeal have agreed with this House, Honorable Speaker, that the judicial arm of the state cannot direct Parliament on what to do and not what to do. Therefore, it follows, Honorable Speaker, that at the opportune time, when this Honorable House has conducted its proceedings, these proceedings will then fall before the judicial arm of the state. And at that time, the judicial arm of the state will have every opportunity to test the proceedings of this House for constitutional compliance. It is agreeable, it is common ground, Honorable Speaker, that the proper judge of compliance with the Constitution and the standing orders of this House and the statutes relating to the removal proceedings of a governor is the judiciary. The question, or the point that is not agreeable by both sides, is at what point can the courts stop an inchoate or an ongoing constitutional process that is before the legislative assemblies. The Supreme Court, Honorable Speaker, in the matter of Martin Jaga Wambora, had occasion to deliberate on this issue. And at pages 6 of our submissions, page 6 and 7, Honorable Speaker, you will find an exposition of what the Supreme Court said. The Supreme Court explicitly forbade, Honorable Speaker, courts from granting orders that stop ongoing proceedings that are before legislative assemblies. And to quote what the court said at page 6, in fact, it is at page 7, Honorable Speaker, no governmental agency should encumber another to stall the constitutional motions of the other. The best practices from the comparative lesson signal that the judicial organ must practice the greatest care in determining the merits of each case. So, the question that arises, therefore, Honorable Speaker, is while the governor impugns or challenges the validity of the impeachment motion, the validity of the court order that was given, which court order is a basis of the challenge that the governor has put up to the propriety of these proceedings, is also in question. The validity of that court order is in question because, Your Lordship, because, Honorable Speaker, the highest court in the Republic have affirmed what this House has stated on numerous occasions, that the judicial arm of the state, though it can intervene to stop or to check for constitutional compliance, that process before the Legislative Assembly should be left to run its full course, and at the opportune time, the judicial arm of the state can intervene to check the propriety of those proceedings. Therefore, Honorable Speaker, can a court, the High Court, and Honorable Speaker, Section 5 of the Judicature Act provides for the hierarchy of laws in our Republic. The Constitution is at the top. Honorable Speaker, the apex court in the Republic, as per our Constitution, is the Supreme Court. The Court of Appeal is next. The decisions of the Supreme Court, as per Article 163(5) of the Constitution, Honorable Speaker, are binding on the High Court. The same goes for the decisions from the Court of Appeal. The question, therefore, is, can this Honorable House be stopped by a court that has disregarded binding precedent? Can this court be stopped by a court that itself is lacking in jurisdiction? Our response or our answer to that question, Honorable Speaker, is that you should proceed unhindered undeterred and render a decision or a determination on the impeachment motion on the merits upon hearing the witnesses that are to be called by the respective parties. The danger, Honorable Speaker, is if this Honorable House was to terminate the proceedings at this stage, then, Your Lord, Honorable Speaker, it would set a very dangerous precedent. And that dangerous precedent, Honorable Speaker, is that all that a governor would need to do is to move to court and obtain an order either quashing the impeachment proceedings before they even begin, or stopping this House from considering the impeachment motion before it is even seized with that impeachment motion. And therefore, Senate would have abdicated its role as a defender of devolution. Senate would have abdicated its oversight mechanism in the removal from office proceedings of county governors. And therefore, Honorable Speaker and the members, as you deliberate on that issue, we sound that caution that whatever is established today will have an implication on future impeachment processes that will be brought before this House. On the second ground of the plea, Honorable Speaker, counsel for the governor have referred to affidavits by the clerk of the assembly and affidavits by the AP commander, Isiolo County. And all these affidavits, Honorable Speaker, have been referred to persuade you that there was no sitting by the assembly on the 26th of June 2025 when the impeachment motion was approved by the county assembly. The question that arises, Honorable Speaker, is whether the contents of those affidavits can established, whether the contents of those affidavits are to be believed without testing the evidence of those witnesses under oath. So the way I see it, Honorable Speaker, is that the governor is asking for a full trial. By making a reference to those affidavits, it must be taken that the governor concedes that that PO is not a pure point of law, is not based on a pure point of law, that can be canvassed by counsel without reference to affidavits by witnesses. The reason we file affidavits before you, Honorable Speaker, is to give advance notice to the other party, so that the other party can prepare on how to test the truthfulness, the credibility, and the veracity of those witnesses when they take the stand to give evidence before this House. So, Honorable Speaker, the contents of those affidavits, the depositions that are contained in those affidavits would have to be tested by way of cross-examination of the witnesses for this Honorable House to make a conclusion on that question as to whether there was a sitting. The same goes for the answer that is impugned by the clerk of the county assembly on oath. With regard to the question of further on that question of the alleged forgery of the answer, all the counsel for the governor has done is to make reference to an affidavit by a witness. Counsel was submitting on what is supposed to be a preliminary point of law. It is no longer a preliminary point of law, Honorable Speaker, if counsel does not restrict himself and now, takes the posture of the witness and testifies on behalf of a witness on what they have deponed under oath in an affidavit. At the opportune time, Honorable Speaker, we'll be praying to cross-examine those witnesses in order to establish the truth. The further question that arises, Honorable Speaker, as I conclude, is the clerk of the assembly under the County Assembly Services Act is required to render expert non-partisan advice to the Speaker and to the House on procedural matters and all other matters that are before the House. We will be craving for an opportunity to cross-examine the clerk on all the issues that Council has alluded to in trying to persuade you, Honorable Speaker, and the House that you dispose of the issue of whether there was a sitting and the issue whether there was forgery of the answered at this preliminary trial. A mini trial that the governor requests for, a trial within a trial, is not necessary, Honorable Speaker, if the issues that are to be canvassed during that mini trial can be established in the full trial. Or that the issues of the sitting of the Assembly, the issues of the alleged fraud, the alleged forgery, are matters that belong to the full trial. It is for the governor to prove that indeed there was forgery, because he's the one who alleges there was forgery of the answered report and that there was no sitting. It is for the governor to prove through evidence that is going to be tested by way of cross-examination at the trial. Therefore, Honorable Speaker, reducing that issue, and it's a very germane issue, the issue of the sitting and the alleged forgery, to a matter that can be handled at this stage without leading evidence, is not only inappropriate, but against the best interest of justice, because the County Assembly will not have the opportunity to cross-examine the witnesses that are being called and those affidavits have been referenced to by the Governor's Council in making that preliminary point. In conclusion, Honorable Speaker, it is only after a lengthy and a drawn-out hearing in the main trial that all these issues that are couched as preliminary objections can be sufficiently addressed. Honorable Speaker, I'll say one last thing on that issue of the court order before I cede a few minutes to my colleague, Mr. Muriuki. Honorable Speaker, the issue of the court order that is the governor has alluded to is not to be looked at just as a standalone issue or as it is essentially, Honorable Speaker, an attack on the jurisdiction of this Honorable House to hear the impeachment motion that this House is seized of. The question, as I said before, is if a court whose jurisdiction is challenged, because in fact, Honorable Speaker, I was in those proceedings and the jurisdiction of the court was challenged. The court has not rendered a decision on a preliminary objection that was filed, but the court proceeded to grant the orders that were granted. Can a court whose jurisdiction is challenged and which court, the apex court in the Republic, together with the Court of Appeal, have held that our court is bereft of jurisdiction, take away the jurisdiction of this House, which is constitutional in nature, the jurisdiction of this House to oversight county assemblies is constitutional in nature. Can a court acting in excess of jurisdiction take away the constitutional mandate of this House? As Mr. Nyamodi quoted just before he took the stand, Honorable Speaker, the decision in Mark 4 on the validity of that court order comes into play. Because, Honorable Speaker, there is no need for that court order to be set aside. The moment that court order was given by a court that has disregarded binding precedents from the Supreme Court, from the Court of Appeal, and acted in excess of jurisdiction, that order is a nullity in law. So much as the court order says that the proceedings before the Assembly were a nullity in law, the court order itself is a nullity in law. There is no further order of court that is required to set aside that order, because that order itself is a nullity in law. It cannot stand. Therefore, Honorable Speaker and the Senators, I urge you, as I conclude, not to cede to the request, not to accede to the request by the governor's lawyers to take away the jurisdiction of this Honorable House on this important question that is before you for determination. I will cede the remaining minutes to my colleague, Mr. Murray.
Honorable Speaker, esteemed members of this House, my name is Eric Murioki. I am privileged to appear before you once again. I represent the County Assembly of Isiolo. Honorable Speaker, esteemed members, to continue with our submissions where my colleague has left off, the question that should seize this House, and Honorable Speaker, when you go to make your determination, is this. On a balance of conveniences, what ought to happen? We submit that this House ought to proceed with these proceedings because, as has been held in numerous court decisions, the governor will have the opportunity to challenge these proceedings in court. However, neither the court nor this House can freeze the statutory and constitutional timelines that are set for impeachment proceedings. So, Honorable Speaker, allowing the PO in the way that the governor's team asks this House to do would irreparably prejudice the Assembly, because there is a chance for the governor to challenge these proceedings, but there is no chance for the Assembly to reinstate or to pause this process and then come back. The proper time to question the validity of impeachment proceedings, as has been ably submitted by my senior Nyamodi, is after the process is complete. And Honorable Speaker and members, this is what the court held in the case of Kawira Mwangaza versus the County Assembly of Meru. Honorable Speaker, this position was also buttressed or had earlier been held in the Mate, the Justice Kariuki Mate matter. Honorable Speaker, allow me to read an excerpt from the decision of the Court of Appeal, that is Mwangaza versus County Assembly of Meru and another, 2023 KECA. We observe that the applicant's right to be heard and to defend herself from the allegations made against her in the impeachment debate at the County Assembly of Meru provided under the standing orders of the County Assembly. If she is impeached, and emphasis on this part, Honorable Speaker, she will have another opportunity to present her case before the Senate during the hearing of the impeachment motion. Further emphasis here, Honorable Speaker, even after the Senate makes its decision, the applicant still has the avenue of petitioning the court for an appropriate relief if the decisions were to go against her. We are therefore of the considered view that the applicant's right to be heard will not be circumscribed. Enough said, this court lacks jurisdiction to consider the application before it for the reasons stated in the ruling. That is the Court of Appeal, Honorable Senators speaking. The second question that this House and Mr. Speaker should ponder is, where is the public interest in this matter? In this matter of the PO. This is an important question. the impeachment process has commenced. The Supreme Court and the Court of Appeal have, in very clear and no uncertain terms, they have forbidden lower courts from granting the kind of orders that the governor has brought here today, saying that he wishes to rely on to scuttle these proceedings. And honorable senators, even where such orders are issued, what does the Supreme Court say? It says that should those orders be issued in error, then the assembly, the county assembly, is entitled to not immediately comply with those orders. Honorable Speaker, these are not my words. These are the words of the Supreme Court itself in the Mati decision. Paragraph 95 of that decision, and it is found in page 8 of our submissions, where the Supreme Court says, it is our understanding that the exceptional circumstances of this case, with a complex scenario of justiciabilities from contrasted standpoints, would lend justification to the non-effectuation of contempt orders at the beginning, and consequently, we would accommodate the reality of their not having been immediate compliance as would otherwise be required. The Supreme Court is recognizing that sometimes court orders are issued in error, and where the effect of those orders is to encumber a House of Parliament, a legislative house, from performing its duties, the Supreme Court is accommodating the reality that those orders do not have to be immediately complied with. Your honorable senators, on this basis, we therefore submit that it is in the public interest that this House dismisses this PO and proceeds to hearing, bearing in mind what the Supreme Court has said, what the Court of Appeal has said. Honorable senators, another issue I want to touch on is the issue of forgery that has been alleged in the governor's preliminary objection. And the only submission I will add to what my colleagues have said on that issue.
Counsel for the County Assembly.
Yes.
Just take your seat. I've got a communication to make. Now, honorable senators, ladies and gentlemen, the time now is 1 p.m. And in terms of our program, we are set out in the order paper. We are set to adjourn at this time. I note, however, that the County Assembly still has 10 minutes of their time. I therefore wish to invoke Standing Order 34-2 and 2A of the standing orders, which permit the Speaker, for the convenience of the Senate, to direct later interruption of the business for a period of not more than 15 minutes. I therefore direct that the County Assembly may utilize its remaining 10 minutes so that the Senate shall adjourn at 1:10 p.m. or such earlier time as the County Assembly concludes its submissions. The Senate then will resume sitting at 2:30 p.m. when the Governor's Council will have its 10 minutes to respond before the Senate proceeds to make a determination on the preliminary objection. It is so directed. Council, you may proceed to utilize your 10 minutes.
Thank you, Mr. Speaker, sir. As I was submitting, honorable senators, is that my colleagues have indeed said, and I agree completely, that forgery must be specifically pleaded and proven. The mere word of the Governor's Council on this pulpit cannot be taken as evidence of forgery. Indeed, in a decision of the Court of Appeal, Jennifer Nyambura Kamau versus Humphrey Bakanandi, the court held that it is also a settled law that fraudulent conduct must be distinctly alleged and distinctly proved. It is not allowable to leave fraud to be inferred from the facts. An allegation of forgery is an issue of fraudulent conduct. Honorable Senators, you have been told that it is a preliminary issue whether there was a sitting and whether from that sitting threshold for impeachment was reached. Honorable Senators, this issue can only be determined after a conclusive hearing of these proceedings. The Governor's Council has stated that they will rely on the affidavit of the clerk, who is an employee of the County Assembly, to tell you that there was no sitting. Honorable Senators, as a matter of fair hearing, we must then be allowed to test the veracity of those averments by the clerk under oath through cross-examination. And for that reason, Honorable Senators, this issue cannot form the basis of a PO. Honorable Senators, from the locus classicus on POs of Mukisa Biscuits, as was again affirmed in the decision that we have quoted in our submissions of Ali Hassan Joe and another versus Suleiman Said Shaban, for a PO to succeed, it must be a pure point of law which is argued on the assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained or if what is sought is the exercise of judicial discretion. And I would perhaps just amend that to also include quasi-judicial discretion, because this House now sits as a quasi-judicial body. So, Honorable Senators, that issue of whether there was a sitting is at length canvassed in both the County Assembly's documents and the Governor's responses. And for that reason, it therefore cannot form part of a preliminary objection. We shall be, of course, adducing evidence to show that there were sittings of the Assembly on those 2 dates, even though there were attempts to scuttle those sittings. Honorable Senators, as I conclude my submissions, we shall lead evidence at the opportune time to show that there was vandalism at the offices of the County Assembly and that the said vandalism was orchestrated by the Governor or at his direction. That is the evidence that we shall bring here. We shall also lead evidence, Honorable Senators, to show that there has been a pattern of attempts to scuttle these impeachment proceedings right from the start, and these attempts were made by the Governor. We shall adduce evidence to show that the Governor took every possible step, whether legal or otherwise, to try and stop and scuttle these impeachment proceedings. For these reasons, Honorable Speaker and Honorable Members, we submit that it is necessary and this House ought to rule that that PO is untenable and that we proceed with hearing of the full case. My colleague will finalize our submissions. Thank you.
Honorable Speaker and members of the Senate, I'll just take a few minutes just to conclude our remarks on behalf of the County Assembly. Honorable Speaker, I would just like to highlight the two-faced approach to the contest raised by the governor. On the one hand, the governor is saying that there was no motion, no resolution passed that is capable of coming before the Senate.
Counsel, for the sake of the Hansard, kindly state your name.
Honorable Speaker, my name is Paulo. Honorable Speaker, before I proceed, my name is Paul Wafula. I'm an advocate. I'm part of the team representing the County Assembly. Honorable Speaker, given the disruption, may I kindly request that I be added some time since I have not utilized my time.
4 minutes.
Most obliged. Honorable Speaker and members of the Senate, I would kindly request to conclude the remarks of the County Assembly by demonstrating the two-faced nature of the contest that the governor has raised. On the one hand, Honorable Speaker and members of the Senate, you are being told that there was no resolution passed by the County Assembly to impeach the governor. And it is for that reason that my learned friends took detailed time to take you through the Hansard, through their evidence, just to show that actually there was no motion or no resolution passed. On the other hand, they have shown, they have made it a point to say that there is a resolution. However, that resolution has been declared null and void by a High Court order. Ipso facto, what the governor is saying, on the other hand, is that actually the County Assembly sat and passed a resolution. And on the second hand, they took that resolution and went to the court, where the court adjudicated on that resolution and found it to be null and void. Honorable Senators and the Speaker, the government needs to take a position. Is it that there was no resolution or there was a resolution? Honorable Speaker and members of the Senate, you have not been told in any uncertain terms there is any constitutional or statutory provision barring this House from conducting its business today. You have not been told that there is any court order barring these proceedings. Absent those two parameters, it is our submission that there is no preliminary objection capable of being sustained in these proceedings. Honorable Speaker, as I conclude, you will note from the various remarks made by my learned friends for the governor and ourselves that the record of whether or not the County Assembly of Isiolo sat is contested. There is a rebuttable explanation for that, and that can only be made when the County Assembly is given an opportunity to present its case. On that basis alone, Honorable Senators and Speaker, we kindly ask this House to disregard the PO raised in the manner it deserves and proceed.
Well, we do apologize for interrupting the current proceedings there at the Senate. It's all about the impeachment of Isiolo Governor Abdi Guyo. Welcome to KBC's Lunchtime News. Quickly, I want to take you to the Kenya School of Government, where President William Ruto is currently addressing at the groundbreaking of the Global Center on Adaptation headquarters. Let's listen into the head state.
Of adaptation, innovation, public service training, and policy support. It will bring together researchers, practitioners, policymakers, and development actors to design and deliver practical, scalable solutions on matters adaptation. Most importantly, it will help strengthen institutional resilience, particularly at the devolved levels of government through specialized training and also through technical support. Through this collaboration, we aim to place climate adaptation at the heart of public service training, performance management, and leadership development. This will ultimately support institutional re-engineering for climate-responsive governance. As a country, we reaffirm our long-term commitment to supporting this initiative. I remember when I visited the floating office in Rotterdam, and I did make a commitment on the behalf of the people and government of Kenya, and in my very strong belief that we have solutions that we can offer. And though we are suffering the effects of climate change, we do not want to be just victims. We want to be part of crafting solutions and crafting a future that all of us can live in. It is my very strong commitment that the old style of trying to point fingers at who did what, or trying to blame one us against the other, or the rivalry between the North and the South will not give us solutions. It is the partnership that we can forge between the South and the North, between those who are responsible and those who are victims. And that is how we are going to craft a solution. We're going to craft a new future that will be sustainable for all of humanity. It is a place in history where Africa must contribute its resources, its natural, human resources, and its expertise and knowledge and understanding to craft a future that is not just sustainable, but a future that serves all of humanity. It is the reason why Kenya has taken a front lead in matters climate action and in providing leadership for our continent as we work towards forging a united front and dealing with the challenges that come with matters climate. Kenya
Well, we do apologize for that technical glitch. It is the head of state currently addressing at the groundbreaking of the Global Center on Adaptation headquarters. Let's head over back there, given that the signal, we're trying to stabilize it. The president earlier on was touching upon the mitigations that the government has put in place when it comes to climate change. He's calling for a collaborative efforts between the government, the private sector and other investors when tackling matters to do with climate change. As and when that particular link will stabilize, will be going back there. But for now, let's inform you on other stories making headlines at this hour. MPs allied to former Deputy President Rigathi Gachagua have vowed to urge the Speaker of the National Assembly, Moses Masika Wetangula, to call for an inquiry into the Saba Saba demonstration that led to the death of 11 people. The MPs have also called on the Speaker to summon the Inspector General of Police, Douglas Kanja, to explain the use of force and officers travelling in unmarked vehicles and covering their faces despite a court order compelling the National Police Service to wear their uniform while conducting their duties during demonstrations. They further called for the international community to take action against high-ranking government officials for Monday's event.
Is to demand for an inquiry on what happened yesterday, because many believe that what happened yesterday was well orchestrated, well planned. We also want to understand how is the political class also being involved to execute this economic sabotage?
It is repugnant to treat young, innocent and harmless Kenyans as criminals.
Kenya National Human Rights was attacked. The goons can be seen vividly, lakini hakuna chochote kimefanyika. Na kwa sababu walikuwa wataje mambo ambayo yatafanyika siku inafuata, basi wakina mama walienda wakavurugwa pale.
And I support that we need to call upon the ICC to start carrying out investigations immediately.
Elsewhere, the National Cohesion and Integration Commission has backed the calls for dialogue meant to address what it cites as a generational mistrust, unemployment, disillusionment among the youth. NCIC has called on stakeholders to participate in its ongoing transgressional conversation, which they say will offer space for discourse, collective reflection and action. They called on political and civic actors to refrain from exploiting the frustrations of Gen Z for political capital. Meanwhile, NCIC has recommended the prosecution of former Deputy President Rigathi Gachagua of utterances said to have been deemed to be hate speech. The utterances, however, were not connected to the Gen Z protest.
The transgenerational conversations, a brainchild of NCIC, was developed in response to the Commission's desire to bridge generational divides in Kenya. Recognizing the increasing discontent between age groups, the NCIC saw the urgent need to create a conducive environment where meaningful dialogue between generations could flourish. 2 cases out of 26 cases have been forwarded to DPP for prosecution. And we are actively listening to what the politicians are saying. As I have said, there is no doubt that goons infiltrated the Gen Z demonstrations.
Still on the Saba Saba aftermath, chaos erupted in Meru County during the Saba Saba protests, leaving several roads blocked with stones thrown by protesters during Monday's Saba Saba protest. The businesses were also affected, with one supermarket torched. Leaders have so far condemned the acts of violence, looting and killing.
Stones thrown on the road, bonfires lit in the middle of the roads, and businesses paralyzed was the order for the day in Meru County. Maguna supermarket went up in flames during the protests that left several businesses devastated. Fire brigade from Meru County government responded to the distress call to put out the flames as police tried to combat the situation. At the same time, women leaders in the National Assembly have united to condemn the acts of violence and killings witnessed during the Saba Saba, terming it as an act of anarchy. Speaking in Kampia Samaki, Baringo County during a women empowerment program, the leaders regretted the misuse of jobless youths to cause instability and further condemned the acts of violence, looting and killings that have seen over 10 people shot dead during the Saba Saba protest.
Tukubali kama mayouth tusitumike na wale watu wabaya. Nyinyi mna nia mzuri, lakini kuna wale watu wako na nia mbaya wanataka kutumia nyinyi. Katika maisha ya leo tunataka amani kuanzia Baringo hadi Nairobi. Sisi watoto wenu wako Nairobi, hata wakiwa huko wawe na usalama.
For Lunchtime News, I am Teresa Mutai.
And in other news, Chief Justice Martha Koome has challenged the National Police Service Commission and the National Heroes Council to solemnly honor their oath of office so as to serve diligently and always act in the public interest. She was speaking while presiding over the oath taking by members of the two institutions.
On Tuesday morning at the Supreme Court, Chief Justice Martha Koome presided over the swearing-in of National Police Service Commissioners Perisi Mdhoni Kimani, Benjamin Juma and Professor Coletta Suda, as well as National Heroes Council member Abdullahi Sheikh Kasim.
That in the exercise of the functions and the powers,
their families, friends and colleagues flocked to witness the occasion.
Perform the functions and exercise the powers.
In her speech, Koome challenged the office holders to take their oath-taking as a sacred commitment to uphold the law.
Your work must always be guided by the highest principles of integrity, impartiality, transparency, and fidelity to the Constitution.
The National Police Service Commission can have its full functioning capacity as guided by Article 246. I know there are still two more members, one for the chairman and another member, and I know in the due course the commission will have its full, it will be full house.
I want to congratulate the newly appointed members and especially the ones of the National Police Service Commission, that you have a heavy task ahead of you.
She wished them success in their new roles and assured them of the judiciary's commitment to work with them in service to the nation.
We are committed to collaborate with you and offer coordination to build a criminal justice system that inspires public confidence and safeguards the rights and safety of all Kenyans.
Chief Justice, because you have been on the ground to swear in our appointees, the appointed people, to the National Heroes Council.
And decision making is not how much we shout our decisions. It is how impactful the decisions we make will change the institutions that we are in.
Leaders from Murang'a County have condemned police brutality following the death of Boniface Kariuki, a hawker from Kangema, who was fatally shot during recent protests here in the capital. Boniface Kariuki succumbed to his injuries while receiving treatment at the Kenyatta Hospital. Murang'a Senator John Nutu visited Kariuki's home in Kangema to condole with the family, where he condemned the police for using excessive force on protesters.
We shall not accept our poor young people to be killed when they are just doing their work of hustling in Nairobi. We were not armed. Boni was not armed. He was an innocent hawker.
Vijana wetu tumezaa na tunawategemea. Kwa hivyo kuua watoto kiholela sio haki, sio kujenga nchi.
The government has ordered fresh vetting for all foreigners from Burundi, Rwanda, DRC and Uganda's Wagisu community living in West Pokot. The directive follows chilling revelations of a suspected cannibalism and organ harvesting ring. West Pokot County Commissioner Khalif Abdullahi said the exercise aims to determine who they are, why are they in that particular region, where they operate and how they got there. 13 Ugandan nationals linked to crimes were arrested and moved to Kitale police station to prevent mob attacks. Khalif said the suspect confessed to killing and human feasting dating back in December 2024. A planned raid on Kapenguria police station was foiled and politicians inciting chaos were warned. Forensic experts have collected crucial evidence now under analysis at the government chemist.
The County Security Committee in its meeting today has directed to vet all aliens from Burundi, Rwanda, Congo, and the community of Wagisu, who have been all suspected to have been involved in this heinous crime of cannibalism and harvesting of organs.
Now, the Nyanza and Western IDP's caucus have expressed concerns over the possibility of a further displacement of people if the current escalation of political tension, described as the sounding of war drums, continues across the country. Eric Oyugi, the caucus director, while speaking during a meeting of its members at the Suneka Market Hall in Bunchari constituency of Kisii County, alleged that both the national government and the opposition were complicit in fueling political unrest through their inflammatory statements. Oyugi urged the parties to de-escalate tensions and embrace dialogue for the sake of national peace and stability.
In this republic, and we don't know that we are causing harm. We are fueling this violence, and we are saying this government, you will fight the war yenye mtu amaliza. Kwa sababu ni nyinyi ndio mmeanzisha.
30 minutes past the hour. We need to take our first breather, but don't go too far. There's still more to update you on in regards to what is happening at the Senate. The current head of state is currently at the Kenya School of Government. The DP is here at the University of Nairobi. And more importantly, in our business segment, we'll be focusing on Women in STEM Africa Summit that is set to be held by July 8th all the way to 10th. We already have the founder and chair with us here in studio, so don't go too far.
Looking to advertise on KBC? KBC announcement services are now available on eCitizen. Visit kbc.ecitizen.go.ke and fill out the online application form. It's simple. 1. Complete the form. 2. Upload required documents. 3. Receive a quotation based on word count. And 4. Get notified via SMS when your announcement is ready. Please note, clearly indicate the type of announcement, service station, and all relevant details. 2. All applications must be made online only. Manual submissions will not be accepted. And 3. Announcements will air after news bulletins. For assistance, reach us on email ecitizen@kbc.co.ke or use our social media handles, Facebook, your Facebook account, and X at your X account. Or you can call us on 0723 892 654 or 0734 780 124. KBC announcements. Simple, fast, and digital.
The Ministry of Health is conducting a typhoid and measles rubella vaccination campaign in all the 47 counties from 5th to 14th July 2025. The typhoid vaccine will be administered to children aged 9 months to 14 years. The measles rubella vaccine will be administered to children aged 9 months to 5 years. These vaccines are safe, effective, and available free of charge at all health facilities, schools, markets, and places of worship near you. Typhoid is a serious disease that spreads through contaminated food and water. Maintain safe water and sanitation even after receiving the typhoid vaccine. Measles is highly contagious. It can cause severe complications and even death. Vaccination against measles offers the best protection against the disease. Let's protect our children from typhoid and measles rubella. This message is brought to you by the Ministry of Health in collaboration with UNICEF and the World Health Organization.
Welcome back and thank you for staying with us. Now, the Kenya Union of Post-Primary Education Teachers in Busia County is urging the government to boost infrastructure and staffing in schools to ensure the success of the competency-based curriculum. KUPPET Secretary General for Busia Branch, Moffat Okisai, says poor infrastructure and teacher shortage are the greatest impediments to the curriculum. He is calling for employment of more teachers to avert a looming educational crisis.
We have three pathways. We have the social sciences, we do have arts and sports science, ambapo tunahitaji walimu wa music and dance. Karibu Busia about huenda tu shule 9 hivi ama 10 ya wako na music. What about the 163 schools? As Busia County nimetaja hakuna shule ambayo iko na nini? Na aviation, metalwork, electricity, building and construction, media studies, none.
Na mnajua mtoto msichana anapokuomba kitu kikataa, hawa watoto machozi yako karibu sana. Huwa wanalia kulia. Labda ni hapa tu kwa shule peke yake. Kwa hivyo let us support our children to make sure they achieve what is required in CBC.
Also, the government is leading efforts to strengthen regional readiness against maritime oil pollution through the Maritime Search and Pollution Response Exercise Field Training Exercise. The training taking place from July 7th to 11th, 2025 at the Bandari Maritime Academy in Mombasa brings together stakeholders from across the region to assess and improve response mechanisms in the event of an oil spill in the Western Indian Ocean. The simulation, coordinated by the Kenya Maritime Authority in collaboration with the Kenya Navy and Kenya Ports Authority, aims to evaluate national and regional preparedness, test emergency protocols, and foster cooperation among neighboring states.
This includes the International Maritime Organization, International Convention on Oil Pollution Preparedness, Response and Cooperation, which is referred to as OPRC 1990, and the Nairobi Convention's Protocol on Cooperation in Combating Marine Pollution in Cases of Emergency in the Eastern African region, both of which Kenya has ratified.
The field exercise, it will involve live simulation. When I say live simulation, it will involve real life simulation, real exercise that you will be able to witness yourself in our port. Deployment of oil pollution control equipment and coordination between agencies at sea and onshore.
Over 5,000 residents of Homa Bay County benefited from free medical services during a health camp held at the Onundu Stadium in Mbita as part of Devolution Sensitization Week. The event, organized by the county government in partnership with other stakeholders, saw Safaricom Foundation announce support for 40 elderly people in the county who will receive medical care for 1 year under the Social Health Authority SHA program. The Council of Governor's CEO, Miremwiti, commended the outreach, citing the initiative aims to enhance access to quality healthcare, particularly among vulnerable groups.
Conditions such as high blood pressure or diabetes that they are unaware of. And so this is part of our effort to improve service delivery to the people of Homa Bay.
Patients that who would require out of this would require for longer treatment. They are then available. Then they are able to access SHA, the SHA benefits, and for the first 40 of these patients that are registered on SHA, M-Pesa Foundation will pay for them for the whole year.
We devised a devolution sensitization week that we were aiming to ensure that we engage with the stakeholders of Homa Bay County for citizen engagement, civic education, bringing awareness to them, and of course getting to understand their voices in terms of governance issues, financing, equity distribution of resources, and the like.
Tana River Senator Danson Mungatana is calling for an end to the rift between the county executive and the assembly over the management of bursaries. According to Tana River Senator Danson Mungatana, the lack of consensus on how the bursary program should be managed is negatively affecting students who had previously relied on the funds to support their education. Mungatana warned that the continued delay could have far-reaching consequences on learners from low-income families.
Representative leadership ya assembly itakaa na governor, tuone kama tutapata mwelekeo ili mwananchi ama mwanafunzi wa Tana River asiumie katikati ya viongozi.
Wabunge wa county na governor hawajaelewana, na ndio maana kuna shida ya basari. Pesa hazitoki. Lamu hapa zinatoka, hapo juu Isiolo zinatoka, hapa Garissa zinatoka, Mombasa kwa Buswama zinatoka, Kilifi kwa Mngaro zinatoka, lakini Tana River hazitoki kwa sababu kuna shida ya maelewano kati ya wabunge wa county na gavana wa county. Tunajaribu kutatua hizo, tunaomba Mungu tutazitatua pengine kabla miaka haija.
And now welcome to the world of business. President William Ruto has signed into law the Division of Revenue Bill 2025, unlocking funds for both the national and county governments in the upcoming financial year. The move paves way for smoother budget planning and a boost in service delivery, especially at the grassroots level. The legislation also seeks to strengthen Kenya's fiscal framework by providing a timely and legally binding guide on how the national revenue will be split, reducing conflict and uncertainty between the two levels of government.
Your Excellency the President, Your Excellency the Deputy President, that is the National Executive,
Excellency was introduced.
Now, our keen focus on our business segment, this interview portion, is on an event that is currently ongoing. Starting today, of course, it's currently ongoing at the Kenyatta International Convention Center all the way to the 10th of this month. It's all about Women in STEM Africa Summit 2025, organized by the Women in Technology and Innovation Africa, that is WITIA, of course, in collaboration with other key stakeholders. The briefing, of course, focusing on a number of issues from AI technology. Where are we as a country and as a continent? To take us through this conversation is none other than Eunice Foreman. She is the founder and chair of WITIA. Welcome.
Thank you so much.
And maybe tell us what is happening at KICC, and in terms of this particular summit, what are you focusing on this year?
Yes, we have just started the Women in STEM Africa Summit at KICC, and the summit is all about advocating for more women to pursue STEM fields. That's science, technology, engineering, and mathematics. So our organization, Women in Technology and Innovation Africa, we founded last year, and we are very keen in creating opportunities for women who are interested to pursue their career in technology and innovation and engineering. And now in the STEM, Women in STEM Africa Summit that is currently happening at KICC, we have a line of speakers, industry experts. We have speakers from leading organizations like Safaricom, and they are going to be speaking and sharing their knowledge and their journey also, as they have already created a successful career. So we expect to have many young women, girls attending, and so they can learn from all those key industry speakers.
Maybe you could tell us what are some of the underlying challenges you might seek to, of course, address in that particular summit. And at the end of the day, given that you're saying you were founded just last year, maybe what are some of these, what are those gaps that you have witnessed in that particular space that not so many women are in the STEM subjects?
Yes, I think that the challenge that we are experiencing is that many of our women, they do not really believe that it is possible for women to build very successful careers in technology and engineering. So it's not very easy to really convince them, okay, this is not very difficult subject. You can pursue mathematics, you can become an engineer, you just have to work very, very hard, because of course it requires a lot of learning, a lot of education. And yes, to overcome these challenges, of course, we have a lineup of programs coming up from this year and next year, where we are going to provide education from the grassroots. So we are looking to partner with local organizations and also the government to help us bring out the word out there and encourage many women to come, so that we want to see gender balance in the STEM industry. Yes.
I wanted to even ask you that particular question. In terms of collaborating in the private sector, there is a government in place which serves the public. So how do you ensure that you come together? You do know this particular administration currently is focusing on digitizing most of the services. Of course, just ensuring that technology is not only embedded here in the capital, but many parts of the country. So as an institution, as an organization, what are you doing to, of course, complement the work the national government is doing?
Yes, as I mentioned, we already have started conversations with local organizations. Even today, during the summit, we had the Office of the President being attended the opening ceremony. That is Harriet Shigai. She has been supporting us. And today in the afternoon, we are expecting the PS, Susan Mageni, to join a fireside chat, a panel, and discuss how we can also collaborate with government organizations in what they are already doing and leverage on that to reach as many women and girls as possible. Yes.
And talking about preparedness as a country, given that I can see some of your themes, you'll even be focusing on artificial intelligence, which is the latest trends within the technology. So as a country and as a private developer, how do you see the country? Are we headed in the right direction in implementing AI here?
Well, I think there is a lot of work that needs to be done. We need a lot of investment. We need to bring not only financial investment, but also skills development. Because we can say, okay, we are going to invest a lot of money in the AI sector, but what about the skills? When skills are missing, then who is going to implement this technology that we are looking to implement? And I believe the government should look that also AI and machine learning, neural networking subjects are implemented in school as early as possible, so that not only girls, but also boys can already know what is happening in the technology world and start coding, not only coding, but also building their own neural networks. Yes.
And we're talking about a job force that at the end of the day, we will see many of them coming out of school wanting a job in this particular sector. So the first question is, are there enough jobs in this particular sector itself? And do you think the schools have done enough in their curriculum to talk about technology and ensure they impact the learners before they go to the job market with adequate skills?
Apart from Women in Technology and Innovation Africa, I also run a software development company, DimeTech Group. So we build software, and also we are using AI tools. So now, speaking from my own experience about if there are adequate jobs in the market, yes, I would say there are jobs, because many organizations, not only us, but also many of our partners, they are looking to hire qualified skilled people in this industry. So the schools, they need to be up to date with what really is happening, because we are moving in a very fast speed, and the changing in curriculum should also happen in a very fast pace, and try to cut a lot of processes in the middle that are delaying. Because if we say, okay, we will implement AI curriculum or machine learning or neural networking next year, but then in other countries, the children are already building this already in primary schools. So the government really needs to look in our curriculum that our young generation, they have started learning this as early as possible. And us as an organization, we would like to create also free education for this. And that is why we are looking to invest into free education and support not only women, but also men, because we believe that as a country we need balance and we need to move forward together.
Yes. And of course, what are some of the emerging challenges you have witnessed even before you organized for this particular summit in that particular sector? What challenges have you witnessed and you're currently addressing as we speak?
Yes, we have experienced, first, of course, skills, finding really people who are fit for the tasks. That is a very big challenge. And of course, also the interest, that people really being interested and trying to understand what is really happening. So this has been a very big challenge. But as I mentioned, we just started today. So people can still come to the KICC, and we have a lined up of panel discussions, keynote speakers, and these are industry experts. These are women who have already built their own solutions. So people are invited to come and listen to those panel discussions and keynote speakers, and yeah.
And maybe what are some of the outcomes you're garnering in that particular summit as and when it concludes? Because summits are called, people come, you discuss, you give out solution at the end of the day. But in terms of implementing the resolutions that you have made within those summits, what measures have you put in place as an organization? And more importantly, on the outcomes that will come out of this particular summit?
Yes, our organization, WITIA, it has a membership. So we are encouraging people who are attending the summit, women, to become our members as well, because we are not only hosting this summit like just any other summit, talking and then we leave, but we want to continue creating impact. And that is why we are encouraging many women to come and join our WITIA membership. So when they join our WITIA membership, then they will have access to not only local knowledge, but also international access of knowledge. Like today, we just signed an MOU with WIMASOMO. And WIMASOMO, it's a German-based organization that is trying to provide the most critical education, that is sexual education for girls here, not only in Kenya, but across Africa. And WIMASOMO, they have access to scientific work and a lot of research materials from other partnering organizations. So with this kind of partnerships, we believe that we can create a lot of impact and access to knowledge. This is what we are mostly looking to, that we have as much information and also really filtered information that is scientifically well researched and peer reviewed and is accessible to, as I said, not only women, but also to men. Yes.
And of course, as we conclude, we are currently in the 21st generation where people are tech savvy, especially a majority of the youth here in the country, in their millions. They know how to operate those technologies without be it their phones, be it the laptops or everything else. So the question is, in terms of ensuring that these people are motivated, they do not lose hope, and most of them do innovation, especially through the creative industries. So how, at the end of the day, you as stakeholders ensure that you have motivated these people properly?
Yeah, we intend to have several programs, and especially the summit now, starting today. Yes, we believe when people come and visit the summit, also visit the exhibition, China Trade Week, that is also running alongside the summit, they get this motivation, because you have seen this before, that people need to see so that they get motivated. So when they see, okay, there are these people who are already doing this, then they also get the drive to really want also to do that. Yes.
Thank you so much. Yes. That is Eunice Foreman, the founder and chair of Women in Technology and Innovation Africa. This summit is currently ongoing. It is the Women in STEM Africa Summit, currently ongoing at the Kenyatta International Convention Center, which is KICC, set to conclude on the 10th of July. The briefing also will be focusing, we've just touched with Eunice here, on the highlights of the summit's theme, including artificial intelligence, green engineering, fintech, cybersecurity, innovation, and upskills for women in STEM. Will feature, of course, key speakers you have just informed us, not just from the national government, but all the way to key stakeholders within the private sector. Do continue with that particular conversation at KICC. But for now, let's inform you on what is happening in other parts of the world, where US President, that is Donald Trump, has officially delayed imposing higher tariffs on U.S. imports, while sending letters to 14 countries, including Japan and South Korea, detailing the levies they face. The latest development comes as a 90-day pause the White House placed on some of its aggressive import taxes was set to expire this week. Details of this and other stories is in our Globe News Roundup.
Trump reinstated the threat of a 25% tax on goods from Japan and South Korea, with potential implementation on August 1st, following a previous suspension of tariffs to facilitate trade negotiations. While the president described the new deadline as firm, but not 100% firm, this move outlines adjustable tariff plans and is viewed by some investment strategists as a negotiation tactic rather than a definitive threat, providing optimism for investors. Trump asserts that these tariffs will safeguard American businesses, stimulate domestic manufacturing, and generate employment. Yet economists contend that they will ultimately increase U.S. prices and curtail international trade. The announcement led to a decline in US share indexes, including a 4% drop for Toyota's US-listed shares. Meanwhile, the UK government plans to ban non-disclosure agreements, NDAs, that silence victims of workplace sexual misconduct or discrimination. An amendment to the Employment Rights Bill will void such confidentiality clauses, a move Deputy Prime Minister Angela Rayner called vital to stamp this practice out. This change, championed by campaigners like Zelda Perkins, who broke her NDA with Harvey Weinstein, aims to prevent the misuse of NDAs and align the UK with countries like Ireland and the US. Finally, Australian Prime Minister Anthony Albanese announced he will visit China, with Beijing keen to strengthen partnerships in areas like AI, green energy, and the digital economy. This marks Albanese's second visit to China since his re-election in May, following a 2023 trip that ended a 7-year diplomatic freeze and emphasized the importance of communication despite differences. His trip coincides with China, Australia's largest trading partner, proposing a review of their decade-old free trade agreements to enhance ties in agriculture and mining and explore new technological growth areas.
Now, President William Ruto has conferred Kenya's highest national honor, the Chief of the Order of the Golden Heart, on a former United Nations Secretary General, that is Ban Ki-moon. The award recognizes Moon's outstanding global leadership, tireless advocacy, and an unwavering commitment to just and sustainable world. The honor comes ahead of the groundbreaking of the Global Center on Adaptation, a new headquarters in Nairobi, an initiative that reflects his lasting impact on sustainable development.
This recognition is a testament to your global leadership. The 8th Secretary General of the United Nations, you distinguish yourself as a bridge builder and a champion of the world's most vulnerable. Your legacy continues to inspire us as we confront the harsh realities of a changing climate here in Africa.
Kenya has always been a great friend of my country. I have one more secret reason to feel the deepest gratitude to you, Mr. President.
And now finally, welcome to sports. Olympic champions, that is Faith Kipyegon and Beatrice Chebet, have returned to the country last night from Eugene, USA, after setting new world records in the 1,500 meters and 5,000 meters respectively.
The challenge we are going through about the tracks. Hiyo imetupea changamoto sana juu mimi nikiprepare safo niliprepare kwa tarmac track. Sikuwa na tartan track across my county where I could train, where I could prepare so well to go and do my best. But ilikuwa challenging. Sometimes I could change my program from going to track session because of rain and going to Fat Lake. So that was a big challenge. Now tumeenda through a lot of challenges, but I hope this message going forward to preparation for the World Championship, it will be very hard for us to train if unaona uwanja hatuna, so to train the World Championship, it will be a very big task for us.
Tunaenda kuketi chini na hawa ndio tuone vile tutasaidiana kupata gold si rahisi, so itabidi tukue teamwork.
Sahi tukienda World Championship that are teamwork, lakini tukienda kitu kama Diamond League mtu nakimbia to your level best, but for World Championship tunaenda kusaidiana, then we see medals. So athlete mwenye na atafika finishing first ndio tunashukuru Mungu.
Sasa tumeenda Tokyo kama a team of 8, Beatrice and Kidor, so we are going there to work hard and bring the medals home.
Indeed, welcome back our champions and congratulations once more to Kipyegon and Chebet. Elsewhere, South Africa's Banyana have sent an early warning to their rivals at the 2025 Total Energies CAF Women's Africa Cup of Nations with a confident 2-0 win over Ghana in their opening Group C clash in Ojuda, Morocco. And remember to catch all the action here on KBC Channel 1. Don't forget, we are truly your sports partner. Now, the 2025 FIFA Club World Cup enters semi-final stage this evening with the 3 European powerhouses and a South American contender vying for the prestigious title. English Premier League side Chelsea will face Brazilian outfit Fluminense in the first semi-final tonight. Now, the Blues are chasing their second Club World Cup crown and aiming to secure their first piece of silverware under the new head coach, that is Enzo Maresca. Chelsea have been dominant in the tournament so far, leading at halftime in 4 their 5 matches. In contrast, Fluminense, who went beaten in the group stage with 1 win and 2 draws, have only led at the break in 2 of their 5 games. The Brazilians finished second in their group behind Borussia Dortmund. This is Chelsea's 3rd appearance in the competition, and they are hoping to become the first English club to lift the Club World Cup title more than once. The second semi-final set for tomorrow evening promises a blockbuster showdown as the UEFA Champions League holders Paris Saint-Germain PSG take on 5-time champions Real Madrid in a classic all-European clash.
Numerical advantage. Pedro Neto, this can seal it into the quarter-final now. In Dewsbury Hall, and the Chelsea celebration will go long and loud tonight.
That off the other side was impressive. Here's Martinelli. Deeper this time. Koulibaly finding space, and it's in. Don't think it would have had the power, but Ruben.
To tennis, where Novak Djokovic overcame a slow start and a spirited challenge from Alex to reach the Wimbledon quarterfinals with a 3-1 win on Monday. Playing in front of Roger Federer, the sub rallied from 4-1 down in the 4th set, winning 5 straight games to seal victory. Chasing a record 25th Grand Slam and a 9th Wimbledon title, Djokovic now faces Italy's Flavio Cobolli for a place in the semi-finals. Despite the loss, he impressed with his speed and grit, pushing Djokovic in one of his toughest matches at the All England club.
Djokovic digs in, and there's the fire that he's been looking for. He ramps it up for the crowd, and once again leads 2-1 in the second set.
Well, that concludes our coverage for KBC's Lunchtime News. Don't forget to join us in our subsequent bulletins at 7 p.m. and 9 p.m. At exactly 2:30 p.m., the Senate will resume its sitting. It is the impeachment of Isiolo Governor, that is Abdi Guyo. The Speaker also is set to rule on the various preliminaries that have been raised by both council, both from the Governor's side and the Assembly. You do not want to miss. Catch every live update of that particular proceeding only here on KBC Channel 1. For now, my name is Abdi Hashim. The sign language interpreter at the bottom end of the screen is Lensa Odingo. Good afternoon for now.
Live from Broadcasting House, Nairobi, Kenya. This is KBC English Service.
Welcome to Beat Time Show, the very best of the 80s and 90s with John Karani, JK.
Timeless music hits across the decades.
This is the place to be after you've had a tough day. Here we celebrate love and life.
Just watch. The sound of KBC English Service.
I'm the host Caroline Wangishi, Carol Gatata Moshero.
My name is Geoffrey Mongai B. News, information and entertainment. KBC English Service, Kenya's official national radio.
It's Women's Africa Cup of